And 7/9/2023.
Writ petitions are partly allowed, disposed of. Interim order dated so and so stands vacated. Both the writ petitions. Yes.
My apologies, my lord. My apologies. I think 55 in the supplementary list, my lord, I have filed an IA. I'm just requesting it to be brought on record. Now. Extremely great. My apologies once again.
Why did I pay for listing the matter, madam?
What matter?
On next Monday, madam.
What matter?
Matter relates to family pension.
Family pension, all right. Monday, yes, Monday.
Item number 49, my lord, plus part heard by Mr. Justice, my lord, you can IR, my lord.
Item 49.
Yes, my lord.
Right. Who's for the respondent?
Yes, I have taken consent.
As submitted by the counsel for the petitioner. Item 49 we listed before the appropriate bench by the registry as it is submitted that the matter was parted before another coordinate bench within bracket Justice UK Nair, Unni Krishnan Nair.
Obliged, my lord.
May I please, Lord? My lord, I beg to mention for listing of two admission matters, my lord.
For admission matter, what subject matter?
One is dismissal from service, my lord.
Oh,
And
okay.
another, my lord,
27th?
May I please, your lordship. Lordship, I beg to mention for listing. Family pension matter, lordship. On Monday, lordship.
Monday, no, not Monday. 27th? You have it on 27th.
There's a motion matter, my lord, filed already on 25/7. Kindly tomorrow, my lord.
Why is it not come?
Not come, my lord. It is also not in defective stage.
Huh?
It's not in defective, my lord. Already it is, my lord, passed, but still not listed. Kindly
Not
tomorrow.
tomorrow, not tomorrow. What is the matter? What is the
Matter, my lord, the one panchayat member contested election alleging by showing a false document, my lord. False education qualification.
Is it before this court?
Yes, my lord.
No. Do not before this court.
My lord.
This is service bench.
Panchayat board is
Panchayat, but this is for election. Then,
panchayat election.
bench 5.
May it please, Your Lordship. I beg to mention item number 41 on behalf of BK Gogoi. The matter listed by order, my lord, but suddenly he is feeling not well. my lord.
Item 41 be listed after 2 weeks. And the prayer made on behalf of the counsel for the petitioner.
Lordship, I beg to mention item number 42, lordship.
Item?
42, lordship.
Forty-
I've already taken consent,
But
lordship.
hearing for the petitioner.
Item 42 on joint request. Matter stands deferred to be listed after 2 weeks.
Next week, there's some urgency in the matter.
2 weeks.
Lordship, can it fix on 27? 2 weeks only.
27th, all
Yes,
right, 27th.
Obliged, lordship.
May I please, Your Lordship? Lordship, I beg to mention for listing of a writ petition for admission column, my lord.
Subject matter?
My lord, we have challenged the selection list in the office of the Director of Information and Public Relation, my lord. Next week, any time.
This is an admission matter.
Yes, ma'am.
All right, 29th.
Oblige.
And I also listed for refer list of case, my lord. Here, my lord, the petitioner retired persons, but only his increment is entitled, but only thing is that his PWD roads or building. So I have implemented long back.
29th?
Supplementary on withdrawal item 7.
As submitted by the counsel to the petitioner on instructions, the writ petitioner does not wish to press the petition any further. Writ petition stands dismissed on withdrawal.
Liberty Lordship. Liberty will granted, Lordship. Liberty will granted, Lordship.
Interim orders, if any, stand vacated. Dismissed on withdrawal with liberty. MS Bibura, APS Force
Transport Department.
Mattering for, on behalf of Mr. SP Das.
SC,
SP Das, on behalf of Mr. SP.
SP Das, MS so-and-so appears on behalf of Mr. SP Das. On behalf of respondent number 4, what is respondent 4?
Private respondent.
On behalf of private respondent number 4. Alright.
Deeply obliged, Lordship.
Can you read from motion item one?
Yeah, in this, my lord, for non-compliance of the continuous non-compliance of judgment and order, my lord, at 65, my lord, relevant portion lordship, page 65. Paragraph 19, can you see, lordship?
Ah. Yes, but this was passed in 17.
17, lordship. Hereafter, my lord, several, my lord, the contempt petitions were filed, lordship. The all Assam, my lord, female attendants association also, my lord, representing other, my lord, my lord, the female attendants also filed contempt petitions, lordship. In that contempt, but those contempt petitions were taken together, lordship, and various orders, my lord, by various orders, my lord, date of complaints was extended on the behalf of the, my lord, respondents, lordship. Last extension, kindly see, lordship, at page 25. Sorry, 125, lordship. My lord, it was last extended on 13/3/2024. My lord, 2 weeks, last paragraph, lordship.
This is what, a pending matter.
My lord, those are pending, lordship.
Ah.
Now subsequently, my lord, all those contempt petitions are also listed together, my lord. Kindly 127, lordship, kindly see order, my lord, of this honorable court. The contempt petitions, lordship, during hearing, my lord, the respondent stated that it was partly complied with, lordship. 10 out of, my lord, 4,066, my lord, female
No, no, no,
attendants.
no. 2017, an order was passed.
Yes, lordship.
Is there any order by the court which says that on the basis of any applications or oral submissions, that the compliance of the order, period of compliance is extended?
My lord, that is at 125, lordship. 2 weeks.
Kindly read 125.
Yes, lordship. The attention of this court has been drawn to the communication dated 29/2/2024, wherein it is stated that 18 financial proposals received by the Directorate of Health Services, Family Welfare have been sent to the Finance Department for concurrence, and as soon as concurrence is received from the Finance Department, Health and Family Welfare Department will issue financial sanction for payments. Today, Mr. S. Aliha, learned counsel for the Finance Department, and Mr. Gogoi, learned standing counsel, Health Department, submit that since the process is on, 2 weeks time may be granted to get back to the court on the concurrence given by Finance Department. Although serious objection has been raised by Mr. M.H. Ahmed, learned counsel for the petitioner, but having regard to the submission made by the learned counsel appearing for the Finance Department, 2 weeks further time is granted to obtain concrete instruction in the matter, and failing which court may consider passing appropriate order. My lord, it means,
What
my
is the
lord,
meaning of this?
my lord, time was, my lord, extended, lordship.
Where?
My lord, 2 weeks time was granted. Earlier, many orders are there, my lord, the office, my lord,
Mr.
response.
Counsel, please don't make submissions without understanding what is the issue here.
Yes,
This is a fresh contempt petition.
yes,
This
lord.
petition that you're filing is a fresh contempt petition. Yes or no?
Yes, lordship.
Yes. So you have filed a contempt petition alleging willful disobedience of an order passed in 2017.
Yes, lordship.
You know there is a time specified in
Yes,
the
lordship.
contempt code.
1 year, lordship. From
Now
violation,
these
from the violation, lordship.
Yes, now this page 125, 126 is not an extension of time for completion.
Now kindly see, my lord, at page 127. Another order.
Will you please listen
Yes.
to the court first?
Yes.
126 is an order granting further time to the council to get instructions in the matter. It has
Yes.
not extended the period of compliance in the original order.
My one order is there, lordship, 17/3/2021,
Page number.
page 67, lordship. Page 67, lordship, Operative portion is lordship. Uh, 122 lordship. Operative portion is a 122 kind of lordship.
Yes.
My lord, from second paragraph lordship.
Hmm.
Upon instruction, the learned counsel for the respondent numbers 2 and 3 has submitted that for payment of the honorarium for all unpaid female attendants of the state, it would have a financial implication of rupees so and so, and it is submitted that the said amount has already been sanctioned and awaited release by the competent authority towards area of about 4,066 employees. It is also submitted that the said figure is subject to the further updatation on verification. It is submitted that the Labor Commissioner Assam in the meanwhile has also raised a query regarding categorization of female attendants, and it is submitted that the circulars issued by the Labor Department of Assam has not placed the female attendants in any particular category. It is submitted that this is also a cause of delay in disbursement. Insofar as the communication by the Labor Commissioner Assam is concerned, the said authorities shall be only be stepping in the event they,
Yes, yes, carry on.
my lord, in the event they find that any labor laws has been violated, for example, the provisions of minimum, this is as regards labor laws. My lord, next, my lord,
Yes.
my lord, insofar as the financial implication of about rupees so and so crore, the project extent of financial implication would not be an impediment for this court to enforce compliance of the judgment and order dated so and so. On a perusal of the said judgment and order dated so and so, this court does not find the said order was made subject to satisfying the unpaid arrear wages to all the female attendants. Therefore, if the respondents are awaiting a receipt of a financial implication for setting the claims of all the female attendants as a plea to not implement the judgment and order dated 23/10/2017, the respondent may be well advised as to whether they are doing so at their own risk. Nothing with
Mr. Ahmed,
Lordship.
please read that provision in the Contempt Act.
my lord, section 20, lordship.
Yes.
My lord, this is my lord, 1 year, my lord, from the date of violation, lordship.
How?
My lord,
2017, order has been passed.
yes, lordship.
You have approached this court in 25.
My lord, initially contempt petitions were filed, lordship.
Ah.
All those contempt petitions, my lord, the respondents paid time, lordship, to my lord comply, lordship. And
So,
this on
How
about
does
my
it,
lord
how
granted
does
time.
it extend the period of limitation under 20? Respondents praying for time will
Yes,
not
Lord.
extend the limitation in your matter. A contempt petition and notice will have to be issued within the limitation. Thereafter, respondents may pray for time. It's a different issue. Respondents praying for time in one matter, how does it extend the limitation in the fresh matter?
Now, this honorable court, my lord, in page 127, kindly see lordship passed order while closing the my lord all contempt petitions, lordship, not all, lordship. The contempt petitions filed by the my lord association, lordship.
Yes.
On 27.
Hmm.
Mr. M. Khan, learned counsel for the petitioner. Heard Mr. M. Khan, Mr. Gogoi, learned counsel appearing for the respondent's finance department as well as health department, government of Assam submits that necessary funds for release of the monthly honorarium to petitioners have already been sanctioned and the payments have also been released. Therefore, submits Mr. Gogoi, nothing survives in this contempt case. Responding to the above, Mr. Khan, learned counsel for the petitioner submits that while many of the petitioners have received the amount, some are yet to receive the same. The petitioners' counsel, however, could not indicate as to which of the petitioners have not received the amount or the
It does
reason
not
for
help
not
you.
doing
It does
so.
not help you.
Be that as it may, it appears
Hmm.
that the respondents have already done the needful for compliance of the court's order. Situated thus, this court is of the opinion that keeping this contempt case pending would not survive any practical purpose. As such, the by granting liberty to those petitioners who continue to remain aggrieved in the matter to avail appropriate legal remedy, this contempt case stands closed, my lord. Liberty was granted, lord.
Liberty for what?
On this, my lord,
Liberty for what?
my lord, get appropriate remedy, my lord.
So you cross the hurdle of
My
section
lord,
20.
context of the order, lordship. Oh, my
You
lord,
have to satisfy this court and cross the hurdle of section 20. That this order has to be interpreted as extension of the limitation by the court without even discussing this matter. Has the court discussed that limitation of 20 in section 20 will be extended by the
not
liberty
discussed,
granted?
lordship, but liberty was granted, lordship.
Liberty was
Context of
granted
the, my lord.
to avail
It is on
appropriate
context.
remedy. Sorry, we are not.
Now, on the
we are-
same day,
we are
lordship,
not-
my lord, on the same day, my lord, I have,
No.
my lord, some
We are
other
dismissing it.
contempt. My lord, in some other contempt petitions, lordship, that is contempt petitions numbers, I have stated in paragraph
No.
11, lordship.
We don't
On the
find
same
it-
day, lordship. Same, these are same honorable court, my lord.
All right,
Why-
Monday. You come on Monday.
My lord, along with these contempt petitions, lordship, my lord.
Why along with
Other contempt petitions.
other contempt petitions, you produce orders and satisfy?
Notices,
Other contempt petitions, notices were issued
yes, lordship.
for right, wrong, whatever reasons.
My lord,
In your matter, you have to satisfy that you are not curtailed by the limitation under section 20. You interpret that, we'll issue notice. It is a mandate of the statute. It is not my wish.
my lord, then all other, my lord,
We
extension
don't
orders
know.
should.
We don't know. If some court has overlooked this provision of section 20, we cannot be bound by that. We are bound by the rationale. We are bound by the ratio in the order or the judgment.
Then, my lord, in my humble prayer, lordship, this contempt petition may be listed along with my lord 209.
No.
Contempt case number.
No. You satisfy this
In
first.
that contempt petition, all orders are there, my lord. Extension order, my lord.
Every
Many
day
other
you
orders are.
satisfy us. You satisfy us. You are asking, you are seeking liberty for bench hunting. What you are asking
Yes, lord.
is a liberty for bench hunting.
No.
You don't want to do it before this court and you want to do it before some other court. We can't permit you to do that.
No, I'm not for that, lordship.
So you satisfy on section 20.
My lord, on this, but
On
then my
18th.
lord, may be listed along with the pending contempt cases,
No.
lordship.
On 18th,
Lordship.
you satisfy the court.
My lord, other orders, my lord.
You produce whatever orders are there.
Yes, lordship. My lord, very voluminous orders,
What?
that is why I have not brought to the lordship. All right, lordship.
Voluminous orders will also have to be read.
Yes, lord. Many petitioners are there, lordship.
You produce only the orders, not
Yes,
the
lordship.
petitioners.
I'll produce, lord.
18th, list on
All right,
18th at the request made by Mr. M. Shaw. Amen.
I think two.
Lord, by order dated 35/2025, Lord, instruction was sought for.
Yes, my lord, I have received previous comment. I will file affidavit.
You want to file affidavit?
Yes, my lord.
File affidavit.
Yes.
How much time you want?
2 weeks time, my lord.
2 weeks time. Mr. T.C. Sutia, learned. Additional senior government advocate submits that instructions have been received. He would like to file an affidavit. Since the instructions have been received, this court is of the view that notice be issued in the matter. Let notice issue returnable 3 weeks. Since Mr. Sutia represents all the respondents, notices are waived. Extra copies, if need be, may be served on the government council within the course of this week. List after 3 weeks. Mr. Mandal appears for the petitioner.
Obligation.
Councilor Namdu.
I can read.
May I please, Lordship, this item may be passed off for the time being and may be taken up with item number 37 of today's list because both are same and
Before,
analogous matters.
in this repetition, the challenge to the notification, which was once considered in item number 37.
Hmm?
In item number 37, the same notification was once considered
with regard to a consequential order. So may I place the order? That's a good.
Very last paragraph.
That is the challenge. They have also filed an affidavit without issuance of the notices.
Pleadings are completed in both the matters.
I have to reply. It's not a reply. Don't you want to go to 37?
This matter is listed today.
Lordship listed to their 37. So Lordship, they have filed an affidavit at this.
Where? In this matter, other matter.
Yeah,
In both
this
the
court,
matters, your
Lordship.
lordship.
Here
In
also
this-
you have filed.
They have filed an affidavit without the issuance of notice, Lordship. This was not
There is
considered.
no bar. So you want both matters to be taken up?
Yes, your lordship.
Lordship, however, I may be allowed to reply to the affidavits they have filed because
All
both
right,
are
you-
contradictory.
You reply in this matter or both matters?
Both matters, Lordship.
All right. Item number, this is item number 3 and 37.
Yes, Lordship.
Both these matters, the 37 is also filed by whom?
Filed by the
So one-
employee who was transferred on the basis of.
One
the
office bearer.
Yes, Lordship.
Item number 4 is filed by the,
Not for 3, Lordship.
item number 3 is filed by the
Association.
All India UCO Bank Officers Association.
They have SLD notification itself.
And item number 37 is filed by an office bearer of the same association
Who is also an
in his
employee.
individual capacity. In both writ petitions, the notifications, communication dated 18/6,
Yes, Lordship. That's page 49.
2025, issued by the Chief General Manager, HRM, PSD, Training and NOL. Has been issued. By modifying the earlier policy, earlier transfer policy, whereby office bearers of the association were required to be exempted from transfer. Stop. The respondent bank, represented by Mr. M. Sharma, has already filed the affidavit. Mr. D. Dhaka, Learned Counsel for the petitioner, prays for further time to complete his instructions in the matter. Since both the matters raise the similar issues, let notice be issued in this matter, returnable after 3 weeks.
Yes, Lordship.
Meanwhile, Mr. Dhaka may file his rejoinders in this item 3 and item 37. Number get a review. But let both these matters be listed again after 3 weeks.
Lordship, interim may be extended in that
Interim
37. 37 is.
Rare, only in 37.
Only
Yes, only
37.
Interim in 37 will continue till the next date fixed. List on 15th September.
Yes, Lordship. Blind.
Item 4.
But in this case, my lord, the government was directed to produce the records as, my lord, and
Some I is fine.
yes, my lord, they have filed an application for vacating the stay, my lord. And in fact, my lord, I would like to reply to that.
We have not even issued notice here.
Yes, lordship.
All right, I will issue notice.
Your Lordship, I have filed, I am appearing for private respondent. Your Lordship, the issue was like this. On 25th of June 2025, the promotion order was issued and along with the posting orders. So on 26th, the private respondent was working in, she was posted in Borpeta Medical College. So she took release order on 26th and she joined at that place of posting on 26th. And this instant
But
case was filed on
You are
20
seeking vacation of the interim order,
or
modification.
or modification to that extent, Your Lordship, because I have joined prior to that, Your Lordship, prior to the filing of this case.
Now, lordship will see, this particular order was issued, my lord, in the evening. It was, my lord, even it was uploaded, it was nowhere available, it was uploaded in the evening at 5:30 minutes. Now, lordship, on the very next day, the private respondent goes and, my lord, joins the place of posting, my lord. So there is something amiss, my lord,
Where?
in the entire, my lord, transfer order. That is our basic allegation, my lord. And the thing is, my lord, the government has come up with a view that the post-terminal academy and clinical, my lord, there is a judgment of this honorable court which says, my lord, it is from the same question, my lord.
Where are you now?
I'm still there, my lord, because of ceremonial, I
You
was
are
on
still
leave.
there and the private respondent is also joined.
Yes, my lord. And in fact,
Unilaterally.
my lord,
No, your lordship, nothing like that, your lordship. Prior to the promotion order, I was posted at Borpeta Medical College as assistant matron. And the petitioner was posted at Darang GNM College as vice principal. She is still there. And I have joined, your lordship, at the civil hospital as a matron, your lordship.
In Maldoy.
Yes, your lordship. Your lordship, the facts are within the narrow campus. 25/6/2025, the order was
Right.
passed.
You are working as a vice principal.
yes, my lord.
In the college. In
Yes.
Maldoy.
Yes.
And she has joined in the hospital.
Yes, your lordship.
Then you are-
Initially,
you
my
are-
lord, I was posted to her post, my lord.
You are
to her place of post.
But before you could join, she has joined.
She joined. That is what, my lord. Now, what has happened, my lord? That is the question, my lord. The order came up in the evening of 25th. 26th, she goes and joins. Lordship,
Where is the bar?
no, there is no bar, my lord. The order was uploaded in the net, my lord. That is what. Even the order was not physically available because it was uploaded in the evening, my lord. And the very next day, she goes and joins.
So,
Now, lordship, the fact remains, my lord. Now, she
did you intimate the respondents that an interim order
yes,
is
yes,
passed?
yes, my lord. Immediately, my lord. In fact, it was passed with the consensus, my lord. The lordship will see the order.
Was it ex parte?
No, my lord.
Yes,
The respondent number, private respondent is concerned, my lord.
Ex parte.
Yes, my lord.
Order is.
Your lordship,
dated-
it was a promotional order. She was transferred to JNM College, JNM school at Dibrugarh.
Hmm.
And I was transferred and posted at Mongoldoy Civil Hospital at Dorong.
Hmm.
She wanted the posting at my place. The reason is that she is from Dorong. And out of 30 years of her career in service, she spent almost only 62 days out of the Dorong district and the rest 30 years at Dorong district itself. In fact, she has made an application at Annexure B, page 19 of her writ petition, that she needs to be posted
No,
there.
so why are you filing a vacating petition now? You already joined.
No, the only thing is that it was passed, your lordship, by suppressing the fact that I have not joined. That fact was not brought before your lordship.
This suppression fact, we don't know because the government council was there.
Yes.
It was not informed that you had already joined.
But your lordship, I have annexed the release order as well as the joining order. If your lordship kindly take up my vacating applications forward.
We are taking it up. Yes. When did you join?
I joined on 26th, your lordship.
The order was passed on 23rd.
25th.
23rd of July. I joined on 26th of June.
June.
Yes, your lordship.
Where is that order?
The release order, your lordship.
You don't know the joining order.
Your lordship will come to page 44 of my vacating application, Annexure 9.
Yes. This is the release order.
This is the release order. I
This is
was
the
released
joining
by.
letter.
Yes, your lordship. The next page, page 45. Your lordship will look at above, left side, receipt. I have joined at the office of the Joint Director of Health Services, Dorong.
Page.
Page 45, right side above, your lordship, receipt number 1277.
Hmm.
This was received by the Joint Director of Health Services. This is the type copy, your lordship. The original copy is at page 49.
No, but the receipt is on page 45, not in page 44.
No, 44 is the release order, your lordship. This is the receipt order by the Joint Director of Health Services, Dorong, wherein I have joined in the office of the Joint Director of Health Services, Dorong, on 26 itself.
No, but this is the order of transfer. Page 45. What is this? Page 45 is the transfer.
No, page 45, 44 is the release order. This is not transfer order, your lordship. This is promotional order. This copy was marked to me. If your lordships kindly come to page 48 below.
Is there no requirement of giving a formal joining order?
I have given, your lordship.
Where?
Page 51.
We wanted to see that.
This is, I have given it to the Superintendent of Mongoldoy Civil Hospital, Mongoldoy, joining report, your lordship.
When did you join?
This is on 27/6/2025. This is at Mongoldoy Civil Hospital.
She's joined already.
Yes, my lord. Lordship will do one thing. Lordship will maintain status quo so far the.
What status quo? How does it affect you?
No, because my lord, promotional come transfer has been challenged, my lord, on certain grounds, my lord. Well, I need to explain that, my lord, because she now the private respondent has brought certain allegations against me. That has to be done, my lord. My only thing, my
You
lord.
have to first satisfy the court that you are not aware of the fact that the
Yes,
person
my
has
lord.
joined.
Because there are two reasons, my lord. That is what I'm trying to impress, my lord. Lordship. I was on leave. I'm still on leave, my lord. Firstly, my lord. She joined, Lordship will see. I'll just take you to the order.
Learned counsel for the parties.
Your lordship will know this is a promotional order. Within 15 days, they have to join your lordship.
In the notice in the eye, the respondent, the opposite parties are represented by the respective counsel, namely the writ petitioner and the state counsel appearing for the health department. This IA is filed for vacating modification of the order. Where is the order?
Your lordship have annexed
Page
the order,
19,
your lordship,
page
page 19.
Order dated 23/7/2025, passed in WPC 3986 of 2025. Stop. The writ petitioner by the said order, by the said writ petition has assailed the promotional orders issued by the state, whereby the petitioner was transferred to and posted in Dibrugarh as what?
As principal JNM training school.
As principal JNM training school, and the private respondent was transferred and posted as
Matron, Mongoldo Civil Hospital.
Mongoldo Civil Hospital, Matron, Mongoldo Civil Hospital. Stop. The petitioner is agreed that for the reasons mentioned in the writ, that she ought to have been posted in the Mongoldo Civil Hospital instead of the private respondent. More particularly where as the petitioner is already in Mongoldo, serving as a principal of the nursing school. Stop. Upon hearing the counsel for the parties, this court by order dated 23/7/2025, while issuing notice, directed the order dated so-and-so, order number so-and-so dated 25/6/2025, and order number so-and-so dated 25/6/2025, whereby the petitioner reflecting the transfer and posting of the petitioner as well as the private respondent number 5, directing the same to be stayed till the next returnable date. Stop. The private respondent, this order was passed ex parte, the private respondent, and therefore this IA has been filed. In the present IA, the respondent number 5 has prayed for vacating modification of the order dated so-and-so on the ground that well prior to the order of stay granted by this court, the private respondent had already joined in a place of posting, having been released from her original place of posting by the order dated 26/6/2025. Stop. The private respondent / applicant had joined in her place of posting by furnishing a joining report dated 27/6/2025, which was duly received by the superintendent Mongoldo Civil Hospital on 27/6/2025. Stop. It is therefore clear that on a day when the order staying the impugned orders, when the order by this court dated 23/7/2025 was issued staying the promotion orders number so-and-so dated so-and-so, so-and-so, the petitioner, private respondent number 5 had already joined in her place of posting as per the promotion order. Stop. It is clear that by virtue of the stay granted by this court by the order dated so and so in WPC so and so, the status of the private respondent will be under a cloud. Stop. This court perhaps would not have granted the interim order had the facts been placed before the court, either by the counsel for the petitioner or by the counsel for the state, that the respondent had already joined in a place of posting on 26/27 of June 2025. Stop. Be that as it may, since the interim order is passed and a vacating petition has been filed, and this court intends to issue notice permitting the respondents to respond, the interim order dated 23/7/2025 stands modified to the extent that status quo as on date shall be maintained. And the service benefits of the private respondent number 5 shall not be affected by virtue of the earlier interim order dated so and so, passed in WPC so and so, which now stands modified by the order passed today.
Deeply
Respondents may complete their pleadings and file necessary objections in the meantime in the IA. Stop. In the writ petition, you write, in view of the order passed in the IA dated so and so, interim order dated 23/7/2025 passed in WPC so and so stands modified to the extent indicated in the order dated today passed in IA number so and so. Respondents may complete their instructions and file necessary affidavit if so advised. Matter be listed after 4 weeks.
Deeply obliged, Your Lordship.
Item 5.
Lordship, here I am praying for some more time. 2 weeks, Lordship.
Some more time.
Yes, fine.
How much time?
2 weeks, Lordship.
2 weeks.
Lordship, my anxiety is that I am not being able to purchase the medicines also, Lordship, due to the financial crisis, Lordship.
Why don't you release the provisional pension at least? He's entitled to some
Yes,
pension.
Lordship.
Release the
Yes.
provisional pension. Mr. MP Sharma, for the petitioner, Mr. B. Chaudhary, Learned Standing Counsel
Agree
Affairs for the Agriculture Department, Mr. B. Chakraborty for Accountant.
That's what in number 4.
Mr. Chaudhary prays for further time to complete his instructions. Stop. He prays for 2 weeks' time. Stop. Counsel for the petitioner on the other end submits that the petitioner is going through extreme financial hardship and is unable to purchase medicines for his requirement as he's suffering from health issues as well. Stop. Considering the hardship faced by the petitioner as urged before this court, we direct the Agriculture Department to expeditiously process for release of a provisional pension to the petitioner without further delay. Let this exercise be completed before the next date of listing. List on 3rd.
Yes.
Item 6.
May I please, Lord? My lord, in this case, an advertisement was issued, my lord, for filling up different posts of Anganwadi.
Will you issue notice?
That's
What else? Heard counsel for parties issue notice in 4 weeks. Mr. H. Chakraborty appears for all the respondents.
All the respondent, Lordship.
Respondents. Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today.
My lord, there is an interim prayer, my lord.
No, Lordship.
What interim prayer?
My lord, please start in, my lord.
Lordship, advertisement was issued on 27/5 to 25, Lordship.
Page?
Please start in, my lord, 1 thing.
Yes, what is the interim period?
Pending disposal of further selection process of Ongonadiwari in respect of Bandharmela 1 in terms of advertising may kindly be.
You're challenging what?
The advertisement, Lordship.
You're challenging the advertisement.
Lordship.
Only
That was
in
published
respect-
on
only in
27/5.
respect of-
Lordship.
What is the status of the advertisement? Selection process?
So, I've got not any, getting any
To my
instruction. Lordship.
information, my lord, selection process has not started yet, my lord.
Then? What is the point in, if it starts, you get an opportunity to also participate. You have applied.
Yes, my lord, as a HSLC candidate. my lord.
Whatever, you have applied.
Yes, my lord.
But if you ask for the interim order, even if they want to go ahead, they will not be able to go ahead. So you want or you don't want?
No, my lord, I want, but my anxiety is that if the other candidate is.
Other candidate is coming, then you have to challenge it. There's no other way. You can't ask for an order saying that except you, nobody else will be appointed.
No, my lord, my case is that, my lord, my candidate should be considered as an HSLC candidate, my lord.
Notice on the interim period, returnable on the same date. List on 17th September.
Obliged.
May I please, your lordship? Lordship, in this matter, the petitioner was appointed as an assistant officer in Mahavira Cooperative Bank.
We'll issue notice.
Okay, lordship.
There is counsel for parties issue notice returnable 4 weeks. Mr. Cordoloy appears for
Respond number 1, 2, and 4, your lordship.
1, 2, and 4. Therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. Steps on respondent 3 by registered post 80 within 1 week from today. Respondents may complete their instructions, file necessary affidavit in the meantime. Yes.
Yes.
May I please, your lordship?
Yes.
My lord, in a departmental proceeding, my lord, I was awarded the punishment of dismissal. And against that, my lord, on 30/4/2025, I prepared an appeal. And that has been kept pending.
Appeal is pending.
Pending.
Oh. Yes, Mr. Goswami.
Lordship, it may be disposed of with a direction that this was the appeal.
You first get the
Lordship,
information. What is the
Lordship,
status?
Status, Lordship. I will give it.
Third, learned counsel for parties. The counsel for the petitioner is agreed by the order of dismissal passed by the disciplinary authority. Stop. The further contention on behalf of the petitioner is that the appeal filed against the order of dismissal has not been disposed of till date and the same has remained pending. Mr. J.K. Goswami will obtain instructions as to the status of the appeal stated to have been filed by the petitioner. List after 2 weeks.
The next item is also same.
All right, same order.
Yeah.
After 2 weeks.
Yeah.
I think they.
Eight, please, Lordship.
Yes.
Chief, clearly notification there is a office memorandum that say compensation, family pension will give him 100%, Lordship, after the date, Lordship. But I have been awarded, Lordship.
But not released.
No, released, Lordship.
Ah.
Family pension compensation has been released. It has been released from 30/07/2024. But my father died in 22, Lordship. 2 years without rejoining the Lordship, it has been not released. My father died 22/11.
Will issue notice?
Lordship, at this stage, please.
Third, learned counsel for the parties issue notice in general 4 weeks. Mr. Sharma.
4. Number 4.
No, who appears for the state?
I'm paying correspondent number 2, Lordship.
PWD? You're appearing?
Lordship.
Mr. A. Chalia appears for respondent number 1,
3,
5, and 6.
3 also.
3, respondent 1, 3, 5, and 6. Mr. A. Chakraborty for 2. Mr. B. Sharma for respondent number 4. Since the respondents are represented by counsels, notices are waived, extra copies be furnished within a period of 1 week from today,
Bless.
least after returnable date.
Bless.
11,
May I please, your lordship, my lord, this petition is directed against non-payment of great fee of 8,700, my lord, as per ROP 2017, man.
Notice,
Lordship.
heard counsel for parties issue notice returnable 4 weeks. Mr.
Lordship,
Is
I'm
that for
appearing-
health?
For all the respondents.
You are appearing for all?
Yes, Lordship.
Mr. A. Cholia appears for all the respondents. Since Mr. Cholia represents the respondents, notices are waived, extra copies be furnished within a period of 1 week from today. Let the respondents complete their instructions and file necessary affidavit in the meantime. All right?
12,
Yes, Mr. War.
My lord, this is a writ petition raising a grievance of stagnation in service. Junior have been considered and promoted, although the post was seniority come merit. Your lordship at this stage will pray for a notice, but since my junior has already been promoted by the impugn order at page 124. So only your lordship will kindly see the interim relief that I have prayed, my lord, at page.
That's a very revengeful interim order.
No, your lordship will consider this one, the second one. First one, let it, second one, your lordship may consider till the next.
That is what I'm saying. He has already even gone ahead. Now you want to stop
No,
him
no,
from going.
the first one your lordship will see to next.
Next
first-
high court.
Yes, that your lordship will, that can take care. The second one, if the post, now this post is vacant, if this post is will filled up, then. Third
No,
party.
you are now currently which post?
My lord, I am now in the post, assistant food analyst,
Then what is the next higher post?
the deputy.
Deputy. And the private respondent who was there, what has happened?
Now, your lordship will find the impugn order at page 124.
124. Yes.
Because if he promoted to next post, then this post will be. He was junior, my lord. First, I was eligible for all these years. I served as a state food analysis in the state of Tripura,
No, I
Meghalaya,
understand.
and all those.
What we are asking you is the private respondent was promoted to the post of deputy food analyst.
Deputy food analyst.
And then now he's gone ahead.
Yes, madam.
He's been further promoted.
He is now promoted as deputy. Now again, he will be promoted to the next post.
So that has to be vacant first.
Yes, madam.
Only then the number 2 can be.
Or your lordship may.
Will issue notice on that.
Your lordship will make that any promotion made in terms of 124 is subject to the result of this case.
No, but this post is not vacant as on date.
No.
It has to be vacant
Yes,
first.
yes, your lordship is absolutely right.
Heard, Mr.
That post was remained vacant for almost 16 years. After 16 years, this person has joined much later than me.
All right,
in
but
service.
he's still there in the post.
And now, since by the impugn order at page 124, he has been promoted. Your lordship will just make an observation that this is now subject to the result of this case.
All right, heard, Mr. P.D. Poor, Learned Senior Counsel, assisted by MS so-and-so. And Mr.
the Upamanu lordship.
The Upamanu for health. No.
Yes, lordship, 1, 2, and 4.
1, 2, and
4, lordship.
4.
I am for 3, my lord.
1, 2, and 4. Mr. C. Borua for Accountant General.
My lord.
Since the respondents represent, respondents 1, 2, 3, 4 are represented by the council, notices are waived. Extra copies we furnished within a period of 1 week from today. Issue notice on respondent 5. Steps to be completed by registered post AD as well as usual course within 1 week from today. The petitioner is aggrieved that her case for promotion to the next higher post was overlooked and private respondent number 5 instead was promoted to the next higher post, which is the post of Deputy Food Analyst. Stop. Petitioner has challenged his promotion to the said post. Stop. This promotion made to the, although several interim prayers are made in the writ petition at this stage, this court is of the view that ends of justice will be met if the promotion made to respondent 5 is made subject to outcome of the writ petition. List this matter after the returnable date.
May I pray for any fixed date on last week of September, 19 September, subject to the, your lordship's.
19 September, all right, 19 September.
I'm deeply obliged.
Yeah, understand. Myself, it has been stopped since 2024 till 2018 till dismissal of my service. Neither matter I have been dismissed matter, nor terminated matter, nor matter any matter.
Why have you stopped salary?
Lordship, from 2006 onwards, he absent, unauthorized absent, pursuant to the
You've
department.
taken some proceedings.
Yes, Lordship. Pursuant to the proceeding, he was
All right.
dismissed from
Heard-
service in the year 2019, Lordship, and
He's
he has.
dismissed.
Yes, Lordship.
Heard learned counsel for parties issued notice return above 4 weeks. Mr. K. Kolita represents all.
Lordship, in this case, Oil India Limited is not a party, only officer are a party.
General manager, Oil India, you have not made a party.
Yes, Lordship.
So who are you claiming the relief against? The authority.
He has to make party, Lordship, Oil India Limited.
But the general is represented by the
He
ordinary.
is the officer of the group.
He is an officer, but he does not represent Oil India. Your grievance is against Oil India. Yes or no?
Yes, sir.
So you have to array him as party,
Right.
array him as a party.
I find matter.
You file it.
I amend the matter to.
I want to continue. The counsel for the petitioner is permitted to implead Oil India Limited as a party respondent, which the petitioner claims, the counsel for the petitioner claims was not arrayed due to oversight. So the petitioner counsel will file amended cause title showing Oil India as the prayer made, oral prayer made is considered and allowed. Petitioner will file amended cause title in the registry within 1 week from today. Matter be listed thereafter. You're not issuing notice now.
Supplementary list for motion item 53.
Yes.
In this case, Lordship, petitioner is agreed with the issuance of that order, Lordship, whereby operationalization of ferry service sought to be transferred to the
Some agreement
limited
has been
company.
entered in.
Now, during the pendency of the writ petition, there is a development, Lordship. The petitioners association was called for a meeting. And in the presence of the director and the limited company, Lordship, the managing director of the limited company has given an assurance that service condition of the petitioners association that will remain intact, Lordship. That is the development. Only apprehension is that the assurance has come from the side of the managing director and not the director. Now, what we have come to know that possibly government is also formulating the policies of attachment and service condition of these employees who are sought to be sent on deputation or attachment to the limited company.
See, your prayer in the letter, in the writ petition is for quashing of
Yes.
25(7). That has become redundant. Now the other prayers of your service being, what is your prayer? What is your grievance now? Apprehension?
Apprehension is that we may lose the status of a government employee.
You will not be a government employee.
Since it is a limited company lordship, that is the apprehension of the petitioner. Now, as per the meeting, that has been taken care of to some
So
extent.
what is to be done here?
In the light of that meeting, lordship may dispose of the petition.
Close the matter.
Heard Mr. A. Ganguly.
Giving them
What we have been
liberty, if they are
asking you-
agree later on, they can
Yes,
always
yes.
come.
That
That
is
liberty may be-
precisely what I want, lordship.
Then I am saying.
Mr. E. Ganguly for the petitioner, Mr. Devajit Saikya, Senior Counsel, Advocate General for the State of Assam, assisted by Ms. P. Barua.
That minus lordship will find at page 76.
The writ petitioner is aggrieved by the, where is that letter of 25/7?
Impugned
Page
by
41.
page 41.
Is aggrieved by the communication dated 25/7/2024, issued by the Deputy General Manager, Assam Inland Waterways Company Limited to the Director, Inland Water Transport, whereby it was informed about the taking over of the Umananda ferry service in November, whereby it was intimated about the handing over process of the ferry service of the Inland Water Transport Division, Silchar and Guwahati-based ferry services to Assam Inland Waterways Company Limited, so that operationalization can be started by AIWCL from September 2024. Stop. The petitioners are employees of the Inland Waters Transport Department, Government of Assam. And now the petitioner is the association.
The petitioner is an
Petitioner is the association comprising of employees who are employed in the Inland Water Transport Department, Government of Assam. They were aggrieved by the taking over of the ferry services by the Assam Inland Waterways Company Limited. Therefore, the writ petition was filed. During the pendency of the writ petition, parley took place between the petitioner organization and the stakeholders, other stakeholders, including the government and the company. And an agreement has been entered into, which has been accepted by the association on behalf of the employees. Under such circumstances, he's a signatory. Who is the signatory?
He is the SOSI is also one of the signatories.
The association is also one of the signatories to the said agreement. Under such circumstances, is it an agreement or memo,
It is not
MOU?
an agreement. It is a minus lordship.
Of the signatory to the minutes of the meeting
Yes,
held
that
between
agreement
the
word should
various
be-
stakeholders. Under such circumstances, at present, the counsel for the petitioner on instruction submits that no further grievance survives in the present writ petition, and the same may therefore be closed. However, giving liberty to the association or any of the employees to approach this court if any such grievances still survives. The respondents do not object to the prayer made. Accordingly, the writ petition stands closed. Interim orders, if any, stands vacated. Pending IAs are also dismissed.
Liberty may be given.
Given liberty, liberty granted. I would be given. With
Highly obliged.
May it please your lordship, this is with respect to a experience certificate, your lordship. I have specific instructions that the person has a photocopy and he doesn't have the original copy, your lordship.
So what can be done?
My respectful submission in this case, your lordship, is that I have submitted the certificates which did not have the counter signatures. But the certificate is a genuine certificate, your lordship. I had the experience. The only thing is that it doesn't have the counter signatures at that point of time. I'm working for a long period of time, your lordship.
What is your grievance of the APDCL? You want a counter signature?
The page 41 for a moment, my lord, the advertisement. Second last paragraph from the bottom, my lord, clause 3. However, they will have to submit certificate regarding their engagement for 3 years from the concerned AGM, my lord. Here, the certificates do not have the endorsement of an AGM. Now,
Where is that certificate that you're relying on?
Page 49, Your Lordship.
40?
49 and 48, Your Lordship.
48.
48. 48 is, yes, sir.
48 is the certificate.
Yes, Your Lordship. Subdivisional engineer, Agomoni Electrical Subdivision.
Assistant General Manager.
Yes, Your Lordship. This doesn't have the signature. Your Lordship, may kindly peruse page 49 for a moment, Your Lordship. That will clarify the entire thing. This is another certificate, subdivisional engineer, Agomoni Electrical Subdivision, APDCL. This was countersigned by the Assistant General Manager, Dhuri Electrical Division.
Now, who will countersign this?
But the other one was not cited.
the actions on the part of the APDCL, my lords, they stem from a direction issued by the division bench of this honorable court. The order, my lords, starts at page 61. Page 75, my lords, is the operative portion. Paragraph 4, there's certain directions were issued, my lords. The appointment of the petitioner and certain other individuals were challenged, my lord, before the learned single judge, then the matter went in appeal to the division bench. Paragraph 4, my lords, at page 75.
Yes.
Under the aforesaid circumstances, we direct the APDCL to conduct an verification exercise of all persons who were appointed to the post of Sahayak. And if it is found that if any of them had submitted her requisite essential certificate documents after the last date of submission or the date fixed by the authorities concerned, or did not submit such certificate, such persons may be identified and their services will be liable to be terminated. However, only after giving notice to them. Now, in pursuance to these directions, my lords, an inquiry was carried out. Their certificates were found to be invalid, my lords.
No. The division bench merely said, furnish the credentials.
Yes,
and
verified. We carried out a verification exercise, my lords.
You carried out a verification and you say that it is not countersigned.
Yes.
Now, the problem here is that we cannot get it countersigned. It is the authority who has issued it. We'll have to get it countersigned.
My lords, at the time of applying for the post, my lord, his response to the advertisement, my lord, he had to furnish that certificate at that very point in time. Not now, my lords.
No. Are you denying this page 48?
Page 48, my
Are you
lord,
saying this is a forged?
Page 48 cannot be possibly a certificate in terms with the requirement under the advertisement, my lord.
That's not what the division bench said. Division bench said that were appointed to the post, and if it is found that any of them had requisite after the last date or did not submit, such persons be identified and their services will be terminated.
This certificate was found to be invalid, my lords.
Which certificate?
This certificate at page 48.
Why is it invalid?
Because it is not it's countersigned by the AGM.
What is the value of a counter signature?
Unless
you deny that this certificate was never issued by the authority, he is an authority under you.
Yes, my lord. But the advertisement specifically says, my lord, it has to be countersigned by the AGM.
Rules are meant to streamline the process, not to create obstructions.
Thereafter, my lord, he submitted another representation saying that
he submitted because you did not accept this. You conduct an inquiry and say that this signature by the subdivisional engineer is false, forged. We'll dismiss it with cost.
For the relevant period in time.
He's what? He's a Sahayak. How does he have the authority or audacity to go to an assistant general manager and ask?
People have been doing that, my lord. All the other people who've been appointed, they've gotten their certificates countersigned.
He may not be as brave, no? So you have to first come to a conclusion. Page 48 is false, forged, doctored. There is no finding on that behalf. You make inquiries from the concerned subdivisional engineer, Agomoni, and you find out whether he had issued this certificate.
But the question, my lord, the clause in the...
He's understand the issue. He's a Sahayak where? What is the nature of his job?
No, he's not a lineman, my lord. He's a Sahayak in the office.
What does he do?
He does office, probably menial works, my lord.
Huh?
Clerical jobs probably in the office.
Clerical job. These assistant general managers.
Yes.
Assistant General Manager is General Manager, he is in Dhubri Electrical Division. Assistant General Manager,
Yes,
and he is working in Agomani Electrical.
it is under the same sub.
Maybe,
Yes.
maybe, but are you proposing that the Assistant General Manager knows all the HOIOCs in all the subdivisions?
The APDCL will carry out an exercise. They'll find out, my lord, the requirement because they had applied under the experience criteria. Experience criteria says, my lord, anyone who applying under the
See,
experience criteria.
thereafter it got qualified by the order of the division bench.
Qualified, my lord, we were directed to undertake a verification exercise.
That's
We've
right.
done that, my
You
lord.
verify.
Yes.
You verify and see whether this particular document is valid or invalid.
My lord, page 61, he was also a party to the writ appeal, my lord. Page
Where
60.
does the writ appeal say that these certificates will have to be countersigned?
The appointments, their appointments were specifically challenged, my lords. There are directions flowing from the Honorable Division Bench. My lord, we've only merely complied with those directions.
You are directed to conduct a verification exercise.
Yes.
What verification exercise did you conduct?
My lord, we've conducted, my lord, they have the.
What verification?
My
Where is
lords-
that order of the authority?
My lords, I'll just place that.
Who conducted the
Yes,
verification?
108.
108 is the order. And there was a earlier writ petition also filed by the same petitioner. It was disposed of with a direction for APDCL, upon APDCL to give them a personal hearing. That order, my lord, that starts at page 103.
No, this is merely on the, you have insisted on countersigned by the whatever assistant general, the general manager.
Yes.
He has not submitted. But how do you say this verification has taken place?
Verification, there was an inquiry, my lord. The committee was constituted, an inquiry was conducted.
The inquiry does not say that the
Well,
certificate.
this is merely an office order, my lords, stemming from the inquiry.
Where is that inquiry?
My lords will give me your date, time I'll place it, my
You
lord.
place it.
Yes.
You show us that the inquiry says that this particular certificate is false or non-existent.
My lords. My lords, may pass it over, I'll just place it, my lords.
All right. 2 o'clock?
Yes, sir.
55.
Yes.
Your Lordship, the leading counsel, Mr. R.B. Fukan, is on legs in another court. The matter may be passed over for timing.
At 2 p.m.
May I please listen? Today's fixed for Lordship, the for instruction, the suspension matter, the Gavura Lordship.
Yes, Gaubuda suspension, who's there? Mr. Doctor?
হয়ে যাবে দীপম বড়া we send letter but we have not received the instruction ballot.
Mr. Thesis Utial, additional
Sometime
city
they
government
will-
advocate, prays for further time. Complete his instruction.
মনে হচ্ছে হয়তো
Matter be listed after 2 weeks. Mr. N. Ahmed for the petition.
Date will fit Lordship.
2 weeks?
2 weeks.
27th?
of letter.
No, 27th will not be 2 weeks, 29th.
It is for admission item 14.
Yes.
This matter, I have been newly engaged, I'll request some time.
All right. This after
2 weeks.
2 weeks. On a prayer made by Mr. D. Gogoi, who submits that he has been recently engaged in the matter as the earlier arguing counsel has been elevated to the bench in the meantime.
All right.
15.
In this matter, Lordship, I pray on behalf of Mr. S. Kolita, Lordship. Lordship, on the last occasion, there was a direction to file a substitution application, Lordship. One of the respondent has expired. Lordship, they decided
Petitioner.
Uttaranchan, Lordship. They could not come, Lordship, due to some difficulty. Lordship will give us some time, Lordship.
Prayer is made on behalf of Mr. S. Kolita, counsel to the petitioner. And that further time be granted to take steps to file substitution petition list after 4 weeks. Mr. D. Gogoi
My lord, on behalf of K. Kolita, my lord, Kon Kolita. A. Sharma, my lord.
appears on behalf of Mr. A. Sharma for the respondents.
2 and 6, 2 to 6, my lord.
2 to 6.
All right.
16.
None appears for the petitioner on call. None had appeared for the petitioner on call on 11/6/2025. Mr. T.C. Sutia appears for the
1 to 5.
state respondents 1 to 5, representing respondents 1 to 5. Purely for the ends of justice, matter stands passed over for the day.
17.
Lord, may kindly peruse the last order passed by your lordship. The standing council was directed whether why pension has not been paid as per the order passed in the repetition measure.
Yes, Panchayat Rural Development,
Lordship will take up after some time. I will call in.
PNRD Standing Council.
Lordship will take up after some time.
Yes.
18.
My lord, the steps upon the respondents are deemed to be served. However, my lord, the petitioner has challenged the impugnation of the respondent for not promoting him to the post of Deputy Director of Fisheries along with his colleague, my lord.
Yes.
My lord, in this case, our affidavit is ready, my lord. We have said it for vetting, my lord. The person concerned is on bereavement, my lord.
My lord, as per the last order,
MS Steve Wapangla, counsel for the petitioner.
consequential order will be passed. That's the last order.
So the respondents were required to file their counter affidavit. So MSS here, learned counsel for the
Fishery Department.
Fishery Department submits that prays for further time of how much time?
Right, my lord.
1 week's time, file the affidavit. Let this matter be listed again after 2 weeks. Or you may like to file a rejoinder. You never know. Matter be listed after 3 weeks, by which time the respondents will file the counter affidavit as prayed for. And in the event the counter affidavit is filed, petitioner is also permitted to file rejoinders.
My lord.
19.
On 13/7, my lord, Maulana friend D. Nath was instructed to bring the instruction, my lord.
Yes, D. Nath, Senior Government Advocate, D. Nath. So after some time.
20.
May I please, Your Lordship? Sir, office note dated 5/8, Lordship. Service upon respondent number 3 is complete, Lordship, and with respect to 1 written answer, I think.
Await service report on respondent number 1.
Also, I appear for 2 and 3.
Mr. M.
That will be
Bhagwati
indicated-
appears for
2 and 3.
respondents 2 and 3.
Let respondent number 2 and 3 be obtained instruction, Lordship.
Huh?
I will definitely bring. He wants instruction, also. I will bring an instruction.
The respondents may complete their instructions and file and it apprise the court as to why the directions contained in the order dated.
Lordship, some portion have been paid to him, Lordship, and some are pending with the AZ, Lordship.
Whether-
AZ is not a party here.
Whether directions contained in the order dated so and so, passed in WPC so and so has been complied.
Copy has not gone so far.
Yes,
Well, the AG is not bad party because this was not sent to so far to, but these are not processed, my lord.
Just now I got
The-
the telephonic instruction. They
Then
said
okay.
that it is pending with the AZ, Lordship. Just now, Lordship.
Then, okay, I'll
Family
look
back.
into matter.
He told me, Lordship, so I took. the-
As I am only counsel for that, I'll look into, let him give me issue.
Lordship, Lordship, Lordship.
but then you can't appear for both.
No, that's why I was not appearing. AG was not party. Now my lord hand will appear.
He has already appeared for the petitioner.
He will appear.
His son can appear.
Son can appear.
Right, list this matter after 3 weeks,
Much obliged.
enabling the respondents to complete their. Yeah. Mr. A. Borwa, for the petition. Whose name is to be recorded?
His name is to be recorded.
What is your name?
A Borwa.
A. Borwa.
Item 21.
This case, the ID card is returned in respect of respondent number 3, my lord.
Await service report for respondents 1, 2, 4, and 5. Matter be listed after 4 weeks. Mr. Talukdar, you're appearing?
Lordship, I am for respondent number, Lordship, 4, my.
You're 4.
4.
Mr. Talukdar appears for respondent 4. Service on respondent 3 as per office note is complete. Await service report for respondent 1, 2, and 5. List after 4 weeks.
22.
Non-compliance of the order dated 18/11/2024 and for non-releasing the substances allowances, my lord. In fact, as per their submission, my lord, these allowances were sanctioned in the year 2020.
Let her obtain instructions here. How much time?
3 weeks time, your
3
lordship.
weeks.
The date may be fixed, my lord.
Subsistence allowance.
Yes, my lord, substances allowance.
Mr. R. Islam for the petitioner, Ms. R. Deka appears for the
Number 2, your lordship.
respondent.
Contempt.
Ms. Deka prays for 3 weeks' time to complete her instructions. Considering the prayer made, let the matter be listed again after 3 weeks on a date to be fixed by the registry.
Obliged.
It will be fixed by the registry.
What's up?
Item 23.
None appears for the petitioner. MS
M. Deca.
M. Deka appears for the respondent. Matter stands passed over.
Lordship, this
Hmm?
I have small prayer, Lordship.
Yes,
This matter may be fixed after 2 weeks, Lordship. We need some time to file our affidavit.
none appears for the petitioner on call. MSM Deka for the respondent. Prays for 2 weeks' time to complete her instructions and file affidavit list after 2 weeks.
Highly authorized.
24.
Well, madam, as per the law, my report, my lord, regarding respondent number 13 and 23, madam, notice was not served, madam. Return back, madam. Regarding, madam, respondent number 13, I have corrected, madam, new address, madam. That she has transferred from, madam, Dibugo to Guwahati, madam. And I-
Mr. Tony Cole, learned counsel for the petitioner, is permitted to take fresh steps on the correct address on respondent number
13 and 23.
23.
13 and 23, madam.
13 and 23, yes. And Mr. Upamanyu for
Respondent number 1 to 4.
respondents number 1 to 4, and the other respondent, Mr. R. Sinha.
For respondent number 5 to 7, 9 to 11.
You give it in writing there.
Okay, Lordship.
Respondents. Respondents may complete their pleadings and file necessary affidavit in the meantime.
Service
25.
Deeply obliged.
Diploma.
May I please, your lordship?
As per office note dated 11/8/2025, neither Etika not answer notice.
Await service report on respondent 3, the IE.
Notice was issued on 4/6, madam.
You want to take fresh steps?
No, my lord,
Await for service report.
which one is this? As impleted. Which one is this? As an impleted respondent, my lord. Finance Department.
You have taken steps, you serve it on the standing council if you want. What is the IA for?
IA for implement, my lord.
Implement.
Fine.
Implement of?
Finance Department, respondent number 3. As a respondent number 3.
So then we have issued notice, so you'll have to wait for notice to be served.
Hello.
As per office note, service report on respondent 3 is awaited. That will be listed after 4 weeks.
Obliged.
Typing item 19.
Yes, Mr.
Well, here I have communicated, but I am awaiting the response. Lordship may kindly take it up next Wednesday.
Huh?
Kindly take it up next Wednesday. Lordship, on last occasion, a copy has been served on me,
Yes.
and I am directed to obtain instruction from the respondent
All right. You want it on 20?
on 20.
Yes. Mr. A.J. Atia for the petitioner, Mr. D. Nath, learned advocate, appearing on behalf of the respondent number. The respondent,
In this matter, my lord,
Ah.
I have not filed the Wakalatnama, but I was present on that day, and
Right.
then
we have requested you. to
Lordship,
appear.
Lordship. I'll obtain the instruction
Appearing for respondent
for the respondent one, my lord.
one,
Lordship.
and the request made by the court on the earlier occasion. Mr. Nath prays for a week's time that the matter be listed again on submits that the matter be listed next Wednesday.
Lordship.
Prayer allowed.
Lordship.
List on Wednesday, 20.
20.
Typing item 17.
Petitioner is not here this time. 2 p.m.
Yes, sir.
Item 26.
Lordship, may pass over a matter for attending Mr. Roy's on legs.
None appears for the petitioner on call. List next week.
27.
May I please your lordship? Lordship, in this matter, we supposed to file reply, but the same could not be filed yet. Some further time may be granted to file this.
Lordship, in this matter, Lordship had granted 2 weeks' time. Thereafter, your Lordship, they have taken 3 dates, your Lordship, the 4th occasion. In the submission, the respondents are taking liberty of your Lordship benevolence, your Lordship.
Short time may
Otherwise,
be
the
granted.
pleadings are.
How much time? 1 week?
After 1 day.
10 days. We'll give you 10 days time.
Yes.
Last opportunity, your Lordship.
Mr. V. Rajkumar for the petitioner. Mr.
KK Medi.
KK Medi appears on behalf of SK Medi, then CGC, who prays for further time to complete his pleadings. Mr. Rajkumar submits that several opportunities have been granted earlier, but the respondents have not responded by filing their counter affidavits. Therefore, as a last opportunity, final opportunity be granted to the respondents to complete their pleadings, to file their affidavit. Accordingly, let the matter be listed again on 29th of August. If no affidavit is filed by then, the court will proceed to hear the matter on the basis of the pleadings available. 29th.
If you're right.
48.
But here, we'll file the affidavit within 1 week, Malak. We received the instructions and
My lord, the
copy of the affidavit received. Some documents it's comparing, that is why within 1 week we'll file.
My lord, no issues. In fact, today's item 46 is also on the same subject. This is regarding, my lord, coverage under the old pension scheme and not the new pension scheme. In fact, there are 6 other petitions also pending, my lord. If we can
Where the
tag them
pleadings are
now, or
complete.
pleadings are not complete in our
complete. In
cases.
fact, in one of the case, I received the instruction to not complete the affidavit. So,
Mr. B. Pathak, learned counsel for the petitioner, Mr. U. Goswami of learned CEC for the respondent. Mr. Goswami renews his praise for 2 weeks.
10 days, Malak, we'll file the
We'll give you 2 weeks.
Malak.
2 weeks time to file your affidavit. List this matter again after 2 weeks. Or 3 weeks, in case you want to file a rejoinder? No.
My lord, my lord.
Let it be after 2 weeks so that you have to file your
46
objection.
was similar, my lord. I have informed. the
46,
CPC, my lord.
similar.
In
very
46,
nice.
however, my lord, pleadings are complete. 46 pleadings are complete.
Counters have been filed.
My lord.
All right, then item 46, since the counters are filed, list this matter along with WPC 546.
My lord. There are 6
Of
other petitions.
24. No, for today we are
My lord.
clubbing only 2 matters.
Deeply.
99.
but in this matter, I want 1 week time to file affidavit. We received the copy of the affidavit, the documents which eligible, that is all I have 1 week's time is required.
Yes. Mr. A. Sahad for the petition, Mr. UK Goswami for Lanet CGC for the respondent who prays for a week's time.
Malak.
File his affidavit. Prayer made is allowed, list after 1 week.
Please,
Your Lordship, that regarding some areas dues, my lord, that affidavit file, my lord, I have got the copy yesterday.
Lordship, I am appealing for respondent number 1 and 2. We have filed the affidavit yesterday. Most probably it has not come.
Yesterday?
Yes,
You have received copies?
Yes, yes, my lord.
Mr. R. Shekhar submits that affidavit has been filed on behalf of respondents 1 and 2.
1 and 2.
The same, however, is not available on record. Mr. C. Goswami on the other end, C. Goswami, counsel for the petitioner on the other end, submits that copies of the affidavit has been served on him. Let the registry trace out the affidavit stated to be filed by respondents 1 and 2 and connect it to the case record and list it after 1
Next
week.
week? Yes.
You want to file a rejoinder?
My lord, I will go through, my lord, if necessary, filing.
List after 2 weeks or 3 weeks?
2 weeks enough.
2 weeks.
My lord, I am sorry, in 23 value item, I was on late, my lord, I could not reach.
I don't know. You have merely passed over. You have not
Yes,
passed
my lord.
any adverse over.
Item 31.
Last occasion, my lord, time was paid for filing the affidavit.
Health
Department, my lord.
Mr. J. Sharma appears for the petitioner. None represents the health department. As per the last order, the health department was permitted to complete their instructions. Since none represents, matter stands deferred to be listed next week.
Next week.
Next week.
52.
My lord, we have received instruction, but I will file affidavit. 2 weeks time may be
Mr. J. Sharma for the petitioner.
granted.
The T.C. Sutial and an additional sitting government advocate submits that he's received instructions. He'd like to file affidavit within 2 weeks. Yes,
For respondent number 6, WR meeting.
Mr.
WR meeting.
W.R. Mehdi.
For respondent number 6, that is Kumar Gogol.
It appears for private respondent number 6,
We will also file an affidavit.
who also submits that he would like to file an affidavit list after 3 weeks.
Well. Obliged.
3 weeks.
Obliged.
Please, your lordship will pass over a matter for a time being, as Mr. Roy is on legs.
Have you filed any objections or what? You want to file?
I mean,
You complete your instructions, let it come next week.
lordship. Yes, sir.
Next week.
Lordship.
20, all right, then 27th.
Or
That's 22nd.
22nd, madam.
Yes.
Obliged. Most of them.
Affidavit
None
sent for
appears-
waiting, affidavit sent for waiting, lordship.
None appears for the petitioner. Mr. A. Chakraborty appears for the respondent. Matter be listed after 1 week.
Obliged, lordship.
35.
Made please. Lordship, in this case, lordship, further time will be required, lordship. If your lordship would see the series of orders that has been passed, lords, they have been directed to produce the records, they have been directed to file the.
What is the
The
grievance?
subject matter is, lord, the petitioner has been dismissed from service without following the due process of law.
Then you call for the records, we'll examine it if you can't
Lordship,
find it.
they have sent one letter, lordship. They have stated that further 2 weeks' time will be required, lordship. They have
For what?
for the submission of appropriate instruction, lordship. My lord, kindly have a look at. Lord.
When was it dismissed?
36.
Okay, heard counsel for parties, then this matter pertains, the petitioner has challenged the order of dismissal. Page number 31.
My lord. Yes, my lord.
Challenge the order of dismissal, whereby the disciplinary authority has dismissed the petitioner from service under provision 311 2B. Inquiry dispensed with.
Yes, my lord. My lord, will see page 29 in 1 day.
Stop. Issue rule, matter be listed for hearing in the month of September. In the event the petitioner.
My lord,
the
may I pray one
respondents-
permission? My lord, the petitioner is going to retire in the end of September.
So,
Therefore, your lordship has intended at the admission stage, this time your lordship would be deciding that issue. And therefore, the records were called for and they were directed to file affidavit. More than 4 or 5 times, they have not complied with.
but this is a matter of dismissal. It will require some hearing.
Lord, for me, Lord, that's why your lordship, Lord, what are the circumstances? Your lordship would see page 29. Pending departmental inquiry, petitioner so-and-so is, he has been suspended. It is dated 29th of June. And on the next day, my lord, that termination issue has been. Lord, they themselves say that pending inquiry, and 1 day, my lord, they have changed the stand, my lord.
We'll have to, whatever it may be, but either they'll produce the records or.
May I pray, my lord, your lordship may take it as an admission hearing, my lord, first week of September, my lord.
Admission hearing.
Route
Yes,
is-
what is their instructions?
Lordship, 2 weeks' time, lordship, going out and the whole instruction, lordship. 2 weeks, lordship.
Matter be listed after 2 weeks, enabling government council to complete their instructions. List after 2 weeks.
2 weeks, lordship. Can I pray for a fixed date, lord? It is not listed, lord. Lord, he will retire next month, lord. That's it.
So, what can be done?
Lordship has seen
We
the
can
order.
extend his service period.
No, I'm not saying that, lord. Lord, what I'm
To
praying for that.
interfere with this order of dismissal. We'll have to examine the matter.
Yes, definitely matter. In fact, your lordship has
List
passed.
again on 15th of September. In the even the affidavit is not filed, court may pass consequential orders.
36.
36 plus affidavit file lots.
File.
I'm a petition file started at 1 p.m. So it is not taken to the file, my lord.
You want to file a rejoinder?
My lord.
All right. Mr. A received for the petitioner, Mr. A Chakraborty, learned government advocate for the respondent who submits that affidavit on behalf of the government has been, respondents have been filed yesterday. Stop. Registry will trace out the affidavit stated to have been filed by the respondent yesterday and connect it to the list records by the next day of listing. Stop. The petitioners are also permitted to file the rejoinder affidavit to these affidavit in opposition stated to have been filed by the respondents. List after 3 weeks.
I am for respond about 9, my lord.
Mr.
2 weeks, no?
He appears for respondent. 2 weeks.
2 weeks. Can it be not 27th or not 29th? If you lordship. And
5th of September.
my lord.
I'm blessed.
Your lordship, respondent number 7 has filed one affidavit. We want to file one reply against that affidavit. Then after 2 weeks.
Counsel for the petitioner prays for 2 weeks' time to file rejoinder affidavit to the affidavit filed by respondent number 7. Mr.
SM Borua.
SN.
SM Borua.
SM Borua appears for
Respondent 7.
respondent 7.
I'm for 1 to 5,
Therefore,
Lord. 1 to 5. 1, 2, 3,
appears
4,
for
5.
respondent 1, 2, 3, 4, 5.
Lordship.
Let the matter be listed again after 2 weeks.
Obliged.
39.
Wait, please, your lordship. Lordship, in this matter, some instruction were sought from regarding the
Cadastral, we have received the instruction that's on.
Yes.
The copy also.
This is vacancy for what?
Vacancy position for the year 2009 and 10, your lordship.
No. For compassionate
Compassion appointment, your lordship. At
so it was available.
what's available.
the grade 4, there's only one number of cadastral, one, your lordship.
Grade 3.
Grade 3.
It's not clear. If it is one post, then how it can be reserved for compassionate appointment?
Rohat division, number of cadastral, 1. Number of men in position is 0. Number of vacancies, 1. Number of vacancy on a compassionate ground is 1, your lordship.
How it can be? You get correct instructions.
Lordship, in this case, Lordship, SLC rejected on Lordship on 14/5/2020, Lordship. He has not challenged this order, Lordship.
And this, we have.
We just want to find out what was the cadre strength on a day when DLC.
If required, I will challenge that order by filing an additional affidavit.
DLC has approved his application. It was forwarded. DLC approved it. Rejection was made by the SLC.
Correct.
Yes.
DLC has to approve it on the basis of vacancies available.
Yes, DLC approved it.
Whether the
vacancy.
Yes, I'll get it.
Your men in position is shown to be 0.
Yes.
This is cadre strength is 1.
1.
How it can be reserved for?
That cannot be reserved, the lordship.
Vacancy, that compassionate appointment. You get your clear instructions.
Very well, lordship.
Mr. R. Gogoi appearing for
PH Department, Lordship.
PHE, sorry. Is permitted 2 weeks further time to get clear instructions from the office of the, from the department as to the vacancy position in the Jorhat division in grade 4 or grade 3 posts for the year 2009 and 10.
My lord, I am praying for a date, my lord.
You're Mr.
Yes, Upadhyay.
S. Upadhyay for the petitioner, Mr. H. Chakraborty for
Respondent 5.
respondent 5. List on 29th.
Deeply obliged, my lord.
Item 40.
May I please, Your Lordship? Madam, this matter pertains to family pension, Lordship. Lordship, though they have released some area amount, Lordship, and also though they have been releasing provisional amount, provisional pension, Lordship, but they have not released GPF, GIS, and leave encashment, Lordship. And
Lordship, we have filed our affidavit to that effect, Lordship. Actually, here in this case, Lordship, since 1998, the petitioner stopped going to the office, Lordship. And after 24 years, Lordship, in the year 2022, he has preferred this writ petition. So the Jorhat Civil Hospital was reconstructed, and it was, Lordship, turned into Lordship Jorhat Medical College in the year 2009. So the documents were not there. So we asked him to produce certain documents for release of the GPF, GIF, and leave engagement. And Lordship, the petitioner's counsel has submitted those documents, but those were not relevant that we have mentioned, Lordship. Otherwise, Lordship, the pleadings are complete in this matter, Lordship. We have filed our reply, they have filed their reply. Lordship, let it.
It is submitted that pleadings are complete in this matter. List again on 28th August.
highly obliged, Your Lordship.
MS so-and-so appears for Accountant General.
Obliged.
Mr. D. Upamanyu for health.
43.
Yes.
No, matter part of non-payment of my lord pension, my lord. The petitioner is the master role worker, my lord, and he post was regular with effect from
Lordship, in this
22.
case, P Nayak APS for the Lordship BTC. These on legs I am told, Lordship.
Respondent number 6 must also filed affidavit, my lord.
Respondent 6 has filed.
Filed, my lord.
Pleadings in the matters are complete and will be listed for admission hearings on 28th.
Obliged, Lordship. Obliged.
Obliged.
44.
I please, Your Lordship. Lordship, a similar matter being numbered as WPC 2835 for 23 is already pending before this honorable court. So matter may be tagged along with it.
What is the relief here? What relief are you praying for?
Lordship, regarding appointment.
Okay. Heard counsel for petitioner, it is submitted that a similar writ petition. A writ petition with similar issues is pending before this court. Being WPC number
2835 of 23.
2835 of
23. 2023.
23. Accordingly, let this writ petition be listed along with the said writ petition number so and so and be listed after 1 week.
Obliged, man.
Yes.
45.
May it please, Your Lordship. Lordship, in this matter, we have sent our affidavit for vetting and signing. We will be filing our affidavit, my lord, within the next week, my lord.
None appears for the petitioner. Mr. A. Fukan for the GAD department.
GAD, my lord, for 2, 3, and 4.
Who submits that the affidavit will be filed within 1 week from today. List again after 2 weeks.
Deeply obliged.
Forty-seven.
46, Lordship.
6. Huh? 46 has been, some order has been passed along with some other matter.
Lordship may record Mr. Gupta's name for the respondents in 46.
I don't know who appeared in, Mr. Medi appeared, I think.
Sir B. Pathak, I think.
No, for the respondent, KK Medi appeared.
Lordship. For 46, Mr. Gupta.
You should have been here then.
Lordship.
All right, yes.
May it please your lordship. My lord, the petitioner challenged the transfer order. She is an contractual employee and she is a data manager. She has transferred from Dharam to Lakhimpur, madam. Sipajhar to Thilamara. My lord, contractual employee transferred for 350 kilometers away from and the impugn order does not reflect the minimum requirement, which is at page 19 at annexure 3. My lord, no whisper has been made regarding public interest or administrative exigencies. Now, my lord, when we have challenged this transfer order, they have filed affidavit in opposition, wherein they have admitted that this transfer order was issued upon complaint against the petitioner, my lord. That is at page 38, filed by the affidavit by respondent number 1 and 2. Kindly peruse page 38, my lord. With reference to the subject select above, it is observed that Ms. Swencho, block data manager, Sipachar BPSC, is found very irregular in her duties. Her performance is not satisfactory at all. Nothing can be justified by her in any review meeting held at district level. Various reports also not uploaded timely and correctly. We have warned her several times, but no change notices till date. Therefore, you are requested to take necessary action like transfer to other district. My lord, kindly come to page 18, page 16. Her transfer, her appointment order. It is of 2012 till 2024. My lord, there is not a single whisper against her. No memo, no warning, nothing.
Where is your appointment order?
At page 16, man, annexure 1.
Where is the terms of agreement?
Yes, we have filed, my lord. On last occasion, your lordship pointed out, we have filed, my lord, that is at page 60, annexure 1 to my additional affidavit. Additional affidavit starts from page 57 and the relevant terms of contractual agreement at page 60 of this additional affidavit. In the terms of the contractual appointment, my lord, there is nothing regarding transferring.
In serial number 8.
Yes, madam.
You have, they have.
My service may be terminated. That's a different issue, man.
And point 6 is also there, my lord. Any action either directly or indirectly of the party for the change of posting will be treated as disqualification for the post.
No, that's a different issue.
How is 6 relevant here?
For change of posting, my lord.
No, please read it properly. This is where the party approaches the authority for a
Exactly.
change of posting.
Yes, my lord.
Here is a case where you have decided to change the place of posting. Yes, what do you have to say?
As per order of this honorable court, my lord, I have annexed my lord transfer policy, my lord, in my additional affidavit, my lord, in page number 48, my lord, of my additional affidavit.
Yes.
The general condition, my lord. General condition 2, my lord, the mission director NRHM reserves the right to transfer or depute any employee at any time if the need arises in the interest of NRHM program. It is independent of this policy, my lord. And this is general condition, my lord, for transfer. And in paragraph 4, my lord, of this additional affidavit, Department begs to state that the petitioner was transferred by the order dated so from Sipazhar to Ghilamara BPHC. This transfer was prompted by a formal complaint received from the district commissioner chairperson of the district health society Dorong district as outlined in the letter dated 10/06/2024, and it was done, my lord, as a punitive action for greater interest of public service only. It is to be reiterated that the complaint details several concerns regarding the petitioner's performance, my lord. Specifically, the petitioner was found very irregular in her duties and her performance was not satisfactory at all. She failed to provide any justification for lack of her progress or improvement in any review meeting held at district level. Furthermore, the petitioner had
Then
repeatedly.
why are you keeping her? Terminate her. If she's so useless, why are you keeping her? What is the point in transferring from A to B? If she's ineffective, she'll be ineffective there also. There has to be a rationale as to why a person is being, you are using it as a punishment. Then you'll have to, the contract employee is okay, but they are also entitled to some, you cannot deprive them of the basic rules of natural justice.
No, so.
He had issued several warnings, my lord, to the
Where
petitioner.
are these warnings? Show us. Do you have
At
it
this time,
close in the affidavit?
No, I have not.
Then, where has the authority issued these warnings? You get the record? Let us see what is there.
Yes.
My lord, it is admitted position, my lord, at page 45, they have admitted that it's a punitive action. And punitive action, my lord, way back in 1985, Supreme Court held that no punitive action. No.
Let us see the judgment.
Yes, ma'am.
Paragraph.
Paragraph 11, my lord. Here, my lord, this one is related to public interest, my lord. No whisper has been made in the transfer order that the transfer was made in public interest. The impugn order merely researched that as the appellant has completed more than 25 years of service, he is
You
retired from
give
the.
us some authority to show that same principles are applicable in
My lord,
respect of
yes, my lord.
contractual or non-governmental employees or contractual employees working under the government.
I'll find his death, man. And let them produce the record.
You produce the records where the grounds are there. Heard Mr. Bushu, learned counsel for the petitioner, G. Bushu, the petitioner, Ms. A. Bora for the NRM,
NHM.
NHM. And Ms. Bora will submits that the petitioner was transferred because there were a lot of complaints in respect of our rendition of service is concerned. She it is submitted that the person did not perform effectively as was desired of her. And in spite of warnings, she did not improve her efficiency. As a consequence thereof, the transfer was ordered. Stop. The pleadings have been completed. However, in the affidavits filed by the respondent, there is no document enclosed to show the warnings or the assessments made, warnings issued to, or the assessments in respect of the writ petition. Let these documents be placed before the court, either by calling for the records or by bringing it on record by way of an affidavit. List again. After 3 weeks.
If date may be fixed, madam. On 3rd September.
5th.
Madam.
5th September.
Deeply obliged.
48.
May it please your lordship. Lordship, the matter pertains to non-payment of retired benefits, lordship. Your lordship, on the last occasion, your lordship had queries regarding the position of the CPI inquiry and directed the judicial department to submit their opinion. In this regard, the judicial department has already rendered their opinion and forwarded it to the PWD department. Now the PWD department is to clear their position with regard to that.
Yes, who's for PWD? Yes.
On last date, I placed one document showing that his provisional pension has already been released. And accordingly, the direction was issued to him, take instruction, lordship. Now today, he is required to apprise this honorable court.
Yes, lordship, the provisional pensions are being funded.
So he is receiving
As per
provisional
directions.
pension, lordship. And so far as the final pension is concerned, lordship, as per the direction issued by the Delhi High Court, lordship, once CBI inquiry was there, it has already submitted its report before the Delhi High Court. So our stand as on date is that until and unless Delhi High Court passes a specific order.
Who has filed who lodged the complaint?
In that case.
Who, before the CBI?
Delhi High Court itself directed, lordship.
Then?
Delhi High Court was in a repetition, lordship, wherein one of the contractor, the main contractor, claimed for release of the entire money, whereas another petition was pending, filed by the subcontractor. He was also claiming the same amount, lordship. In that case, lordship, Delhi High Court passed the direction as in terms of the contract, lordship, subcontract was not allowed beyond 49%. And the concerned engineer, lordship, that is the petitioner, who allowed subcontract in respect of the entire contract, lordship. That was the issue before the Delhi High Court. Accordingly, CBI was directed to conduct an inquiry. That inquiry report has already been submitted. It is before the Delhi High Court, lordship.
So what is the status there?
That status, next date is on 22nd, lordship.
No, but unless you know that there is some criminal complaint against the petitioner.
Against him, lordship, DP is also going on. So we have, as on date, lordship, we have released the provisional pension.
What is the status of the DP?
DP, lordship, he has filed his reply. He has filed his reply. So cause has already been issued. He filed his reply. It is presently going on, lordship. Exact status, lordship, I have to take instruction. but he has filed his reply.
Have you moved his papers before the governor? For stoppage of pension?
No, stoppage of pension because of that no demand certificate has not yet been issued because of the Delhi High Court case, Lordship. Once that case is over, Lordship.
That power is not reserved. The person retires, you have to release pension.
No,
except
till the
after 20
final, no, my submission is that till the finalization, Lordship, he will keep
You
getting.
don't have the power to stop the pension. How are you stopping it? It's
Pension,
reserved only
no,
for the government.
we have not stopped, no specific decision is there, but we have not yet finalized.
This is exactly what I'm asking you. Non-finalization is stoppage of pension. You don't have the power not to finalize. Why have you not finalized?
Lordship. But otherwise, Lordship, he is getting provisional pension.
There's no power. You are not given the power to interfere with somebody's pension. You have to complete papers and send it. Unless under 21.
Yes, the 21 is there.
21, have you moved for 21?
So if Lordship permits me, Lordship, my affidavit is also not there, Lordship. Lordship may grant me some time to get the entire instruction, Lordship, and find one detailed affidavit, Lordship. In the meantime, Lordship, on 22nd, what happens before the Delhi High Court? That
What? Delhi High Court?
Same
What,
issue.
what is Delhi High Court? Is the Delhi High Court
Yes,
directed you
in the
to-
CBI report,
No,
Lordship.
has the Delhi High Court directed the Assam PWD not to release the
No,
pension?
in the
Then
CBI report, Lordship, he has been inducted, Lordship. That is the only issue here.
Who has your powers for release of pension is governed by pension code. Show
21.
me one provision where the administrative department has the power to withhold.
Yeah. Lordship.
Then how are you withholding? You can't withhold unless you follow the procedure. Hey, you're not following the procedure. You are not withholding it, but you're delaying it.
Yes, that no demand
Purposefully.
certificate has not yet been issued. That is-
Purposefully.
Yes, maybe.
This is contrary to the provisions of the code framed by your government.
So, Lordship, at this moment, I'm praying, let me have that instruction, a complete instruction, Lordship. I also would like to file one affidavit, Lordship.
Please do it as early as possible.
Lordship.
Only issue is not issuing the no demand certificate, no yes certificate. No claim certificate.
Who is to issue the no demand?
No demand. That is the only issue by the respondent number 5.
List on 29th of August.
He is only getting the provisional pension.
List on 29th. You get your affidavits, get your instructions. There is no way to hold up somebody's pension like this.
Lordship. Without passing
Who is the respondent 5?
He is the
executive engineer.
executive
We'll
engineer.
call him
PWD
to
Golaghat.
court. Under what authority
He
is
has,
he not
he has
issuing it?
already communicated the issue before the higher authority, Lordship.
He has to issue, has he been instructed by somebody not to issue?
No, he has been instructed to issue.
Then why is this?
By the affidavit, let's will find the affidavit. Higher officials has instructed to issue. Oh,
Who is this authority? Respondent 5?
He's the executive engineer, Lord.
We have to call him to court like this. He is not issuing it.
এখন হেৰি এখন affidavit হ'ল আপোনাৰ respondent number 2. প্ৰণৱজ্যোতি ব্ৰহ্মচাৰী under secretary.
Lordship will take up this matter on 29, Lordship. Done. I will have the complete instruction on the
List on 29th, it is informed to the court by the counsel for the petitioner that the pension of the petitioner, regular pension of the petitioner has not been released in view of the no due certificate not being issued by the respondent number 5. Stop. Mr. Nayak on the other end, additional AG, Mr. Nayak on the other end, prays for some time to complete his instructions and file all necessary affidavits in the matter required. Enabling Mr. Nayak to complete his instructions, let this matter be listed on 29th. The respondents will also apprise the court why the respondent 5 has not issued the no due certificate.
Lordship.
On the next date fixed, list on 29th.
And for respondent.
Mr. Boro for respondent number 5.
Pension and other retired benefits, GPF leave encashment.
Pension and other retired benefits.
Lordship.
Supplemental is for admittal item 57.
Can this matter be taken up after some time, Lordship? Mr. DP Bora is on lakes, Lordship, he is appearing.
You get your instructions, what else?
Yes, Lord.
Have you filed anything? We have issued notice, I think.
Yes, Lord.
Have you filed your
No,
counters?
no, Lordship.
Then
But Lordship, he might be having some instruction. there.
what instructions?
Lordship, then we'll file, Lordship.
Mr. J. Patwari for the petitioner, Mr. D. Upamanyu for the Health Department. The respondents, pursuant to issuance of notice, respondents have not filed any affidavit. Mr. Have we issued notice?
Yes, my lord, that penalty, my lord, from the bottom, my lord.
No, we did not issue notice.
But it has come to.
We did not issue notice.
Then lordship will issue.
All right, let him come.
Yes, Lordship.
I think he mentioned that he may have some instructions and on basis of that
Let
the
him
court
come.
may proceed.
After some time.
Yes, after
Obliged.
some time.
Then
After some time.
it should have come under the motion column,
Where is it come?
under the admission column.
I think 58 to 66.
Yes.
My lord, in this matter, my lord, maybe taken away next week, my lord. M. Bhattacharya, she is dealing with the matter.
My lord, maybe after that, my lord.
Yes.
First week of September, man.
All right.
We have filed a modification.
Let the
Intellectual
matter
order,
be listed after 2 weeks. As it is submitted, the learned additional senior government advocate MS M. Bhattacharya is in bereavement. M. Bhattacharya, who had represented the government, is in bereavement. List again on 2nd of February, 2nd of September.
2nd of September, madam.
Mr. T.C. Sutia appears for the respondents.
They did it for hearing item 50.
In the instant matter, Millet, a consensus has been arrived at between the petitioner and the respondent NHIDCL, whereby NHIDCL has given her an offer that they are willing to reinstate her, and in pursuance thereof, Millet, she has joined the services at a higher post with a pay hike. So the matter may be disposed of, Millet.
Yes, Mr. Sokia.
Considering the fact that
She has been appointed, my lord, as a
at a higher post.
manager legal, my lord.
Sometimes good counsel prevails.
Considering my lord's queries
This
in the
thing,
previous dates.
my lord, again, my lord, reiterating the whole things, but it is not that, my lord. See, during, my lord,
We are not even inclined to listen to it now that.
Lordship, my lord.
Let me dispose it of
Every time, my
in
lord,
light of the agreement.
Heard counsel for the parties, Mr. Hendick for the petitioner, Mr. P.J. Soikia, senior counsel assisted by MS M. Nirola, appearing for the respondents. During the pendency of the writ petition, the parties have resolved the issues and an offer of appointment to the post of manager legal. What is it? Manager legal in the NHIDCL has been offered to the petitioner with effect from August 1st of August 2025.
She has also joined.
It is submitted by the petitioner that the petitioner has joined
the services.
Has accepted the offer and joined in the services with effect from.
Well, at that
All right,
date,
joined in the services pursuant to the communication dated 12/8/2025. Stop. In that view of the matter, counsel for the petitioner submits that there is no further cause to pursue in the matter, and the writ petition can be closed. Mr. Soikia also does not object to the prayer made. Accordingly, writ petition stands closed, disposed of. Interim orders, if any, stands vacated. Pending ayes are also dismissed. Copy of the offer of appointment submitted before the court is kept
But this is
in the
not
case
a,
record.
this is not a letter of offer, this is a communication to the emitter.
Communicating the offer of appointment
To, this is a communication to the council.
to the council is kept on record.
This one 1 and 10 and 2.
Yes,
We appeared for the respondent number 1 to 10 and 12.
NHIDCL.
And it's
1 to 10 and
12.
12. We have 20 minutes, Mr. Rawal.
Yes.
If it's all right with you or?
It is.
All right.
Well, I'm very grateful. In fact, there was some confusion. There were two supplementary lists showing on the website of your Lordship's court. In one, it is showing at 55, another it's showing at 68. So, my Lord, I thought in any case, let me come here before lunch.
There are some judgments which are coming up, so therefore. Matters of.
No, but both are still displaying on the website.
Okay.
I think 68.
Well, yesterday I was on the point of just placing paragraphs of the judgment on promissory estoppel and legitimate expectation. Well, in my humble submission, whenever any of these doctrines are to be invoked, there must be a case made out in the pleadings. Yes. Therefore, I am only giving to your Lordship's the paragraph numbers where I have taken this plea. The paragraph numbers are in the writ petition, paragraph 2, which gives details of who the petitioners are, when they were admitted, and when they were enrolled, when they successfully completed.
Yes.
And those details, along with a table at annexures 1A to 1J, which shows respective dates of each one of them. And those tables, your Lordship will be pleased to find at page 132, Lordship need not trouble, my Lord, to 156. This is, my Lord, only pointing out, I'm pointing out with a view to possibly overcome any submission or reply by the state, my Lord. I'm trying to see nothing.
Page number?
My Lord, the averment is at page 96, paragraph 2 to page 99. And the detailed chart.
96 to?
99.
99.
The averments in the writ petition.
But there's one I just noticed the counsel for the respondent is not there. Where's the health department?
I informed.
I can wait for once.
Yes.
Lordship, Mr. Dipivara is on legs, Lordship.
So the senior counsel wants to complete his arguments. You can take notes. You are assisting him.
Lordship, I have another matter in court number 24.
I'll wait. It's not fair since all throughout we have been doing it in his presence. I leave it to your Lordship.
This is a parted matter. It has to get precedence over other matters. You take your seat, take notes. You take notes. Yes, you take notes.
Lordship, let me inform him because I have another matter in court number 24 bail matter. So I'm just informing him.
No, let him do his duty. We don't want him to be in trouble because we'll come back at 2.
Yes. I believe that.
How much time would you require?
As I indicated, Malot, I'll finish. I had a kind of about 25 minutes. I just give the paragraphs because if I start reading, Malot, everything will take long. But I indicate the paragraph numbers, the page numbers, and I'll show the reply of the state.
No, because there are certain leftover matters which are ready for at 2 p.m. So either we call up those and we.
Well, it's your Lordship's discretion.
Matter. 4 matters. We'll come back and see. There are only about 4 or 5.
I'll be here. Very good.
Writ petition is partly allowed, disposed of. Order cost. Records, if any, remitted back.
Much obliged.
WDP 50 of 2023.
This writ petition stands disposed of in terms of certain directions in paragraph 28 above. The interim order must be extended till disposal of the proceedings before the Lokayukto as directed. Writ petition disposed of accordingly.
WBC 172 of 2023.
Writ petition dismissed. No merits.
WBC 231 of 2023.
Matter is remanded back to the respondent authority, namely respondent 2, to carry out the directions issued by this court in the light of the judgment and law laid down by the apex court. So-and-so versus so-and-so, impugned order dated 10/11/22, accepting resignation of the petitioner with effect from 31/10/2017 is set aside to enable the respondent authority to pass a speaking order afresh in the matter if the application for continuation of service is found to have been submitted by the petitioner, then the petitioner will be allowed to continue in service. And the question of release of back wages is left open to the authorities to be decided. Matter stands disposed of in terms of the above.
WBC 29 of 2024.
Writ petition allowed. No order is to cost.
Much obliged.
Thank you. Disconnect. We'll just call up the time being items so that we'll finish off.
Mr. Bora was here. He said he's in a matter which is likely to take about 10 minutes, but I could start. His colleague is here.
Right.
Timing item 17.
Yes.
Also, as per the last order, the department was, I guess is that my lord, petition was directed, was disposed of with a direction to pay pension to the members of the association as per the rate of their regularization, taking into account. Accordingly, my lord, that has not been complied with.
Yes, Mr. Moore.
Your lordship gave another petition, your lordship. The coordinate bench has allowed the writ petition. The state has preferred appeal. The division bench has dismissed the state's appeal as saying that they will not, the division bench never did not interfere with the single bench judgment. The single bench judgment says, your lordship, the writ petitioner's case will be governed by the another division bench judgment, where it is saying it is provided that their services will be counted from the date of initial appointment.
Here, your lordship, the admittedly, the petitioner was working against a non-sanctioned post till his date of regularization. And after regularization, by way of another order, your lordship, the prospect created ex prospect.
Where is the order that you are seeking comply?
But that starts at page 9, start from page 9. And actually the order starts at page 29. And the operative portion, the direction precisely, lordship, at page 33, paragraph 10. Lordship has got it, man.
Yes.
Accordingly, as the order dated so-and-so passed by this court in WPC number so-and-so has been affirmed by the division bench of this court, by order dated so-and-so passed in writ appeal number 133 of 2023, these writ petitions stand allowed by directing the respondent authorities to pass appropriate orders on the entitlement of the Gao Panchayat secretaries to pension under Assam Services Pension Rules 1969. That is important, but taking note of the respective dates of their regularization. Our case in the writ petition was that our services were regularized in the year 2003. That is prior to the coming of the new defined contributory pension scheme. Therefore, it should be paid under the.
No, what was the decision of the division bench?
That has been annexed in the next page, madam. The division bench or
yes.
page 35.
Also discuss on the process.
What is the decision of the division bench? Conclusion of the division bench?
Yes, sir.
The conclusion of the division bench as regards
page number.
Decision in bench. Page 49, my lord. Pension rules 1969. Got it, page 49. See, my lord, next page. The aforesaid communication, more particularly the communication dated 35/2023, clearly discloses that the salary of the GP secretaries are to be paid by the government. In view of such factual backdrop, the case of the petitioner shall be covered by Assam Services Pension Rule 1969.
In this same page, your lordship, the paragraph B may kindly be perused, your lordship. Same page, your lordship, paragraph B of the judgment. A conjoint reading of the communications dated 35/2003, 4/2006, and 28/3/2018 leaves no room of doubt that posts were created by the state ex post facto with effect from 35/2003, and therefore it can safely be concluded that the service of the petitioner is to be treated as an appointment in a substantive post with effect from 10/6/2003.
And that precisely was our case in the writ petition, madam. But since our services dated back to 2003, that is prior to coming of the new defined contributory pension scheme, the petition that the members of the association are to be given pension under the old pension scheme.
No.
Now you
No, they are
lordship,
not getting, my lord.
it is said division bench judgment, your lordship. May kindly see the last paragraph of the judgment, your lordship. Here, your lordship, in view of the aforesaid decision, discussion, and reason, this court dismisses the present writ appeal being devoid of any merit and resultantly uphold the impugned decision dated 5/8/2022 rendered by the learned single judge in WPC number such and such. So, your lordship, against this judgment, we preferred an SLP, and the Honorable Supreme Court has given us liberty for seeking clarification from our High Court, your lordship. We preferred a clarification petition where, your lordship, it is not clearly.
That annex, lordship, additional affidavit, my lord, lordship, at flag A, page 71 of the additional affidavit filed by the petitioners. That order is annexed. Annexer B, page 71. As per my understanding, my lord, this has been clarified. Page 72 is the order.
So it is clarified.
Yes, madam.
Your lordship, from which date it will be counted, that is not.
10/6.
10/6/2003, my lord. That's what our prayer in the writ petition.
It is the order in the, you want a further clarification of this order?
Your lordship, whatever your lordship, first, it is the order, subsequently the order passed by the government. It was issued by the executive officers regularizing the writ petitioner service, your lordship.
Yes, that is the date. We also want from that day, my lord.
No, we've not understood. What is your confusion now?
Your lordship, if the single bench judgment says that it will be governed by the further of this case, the earlier division bench judgment, it will be counted from the date of initial appointment.
The single bench judgment gets merged with the division bench judgment, which gets merged with the clarificatory order. What do you want? This is your order, page 72.
Yes, your lordship.
That you get them regularized with effect from 10/6.
Yes, yes, your lordship. Then we'll comply with them. If it is 10/6/2003, your lordship.
Heard counsel for parties, his contempt petition is filed with the petitioner, seeking a direction to alleging willful disobedience of non-compliance of the directions contained in the judgment and order dated 11/8/2023, passed in WPC 4506 of 2018 and other connected petitions. By the said judgment, the coordinate bench disposed of the writ petitions, allowed the claims of the petitioners therein, placing reliance on the judgment rendered in placing reliance on the judgment passed by the said coordinate bench in which was the judgment which was upheld in 133.
Your lordship, the 5/8/2022 order dated passed in WPC number 4397/2022.
By placing reliance on the judgment dated 5/8/2022, passed in WPC 4397 of 2022. The said judgment came to be affirmed by a division bench of this court in WA 133 of 2023 on 5/8/2023. Stop. Being still agreed, the state went to the apex court filing an SLP, which came to be disposed of, giving liberty to the state to file an application seeking clarification before the division bench. Stop. Pursuant thereto, the application was duly filed and in IA number 237 of 2025, passed in WPC, by the order dated 2005/2025, the following order was passed, extract 72. Stop. But under such circumstances, it is now clear that the respondents are required to comply with the directions contained in the order dated 11/8/2022, passed in WPC 4506 of 2018 and other connected writ petitions, and to regularize the services of the petitioners with effect from 10/6/2023 and not before that. Stop. This order came to be, having been passed on 2005/2025, the respondents are permitted 60 days.
Yes, sir.
60 days, further 60 days from the date of 60 days from today.
For settlement of pension.
60 days from the date of receipt of a certified copy of this order, and to comply the same directions. Stop. We list it after 2 months.
Lordship, a fixed date may be given, my lord. In the meantime, they may.
Matter be listed after 60 days on a date to be fixed by the registry.
And your lordship, the cutoff date will be 10/6/2003. Your lordship.
It's written in the order.
Written in the order. Okay. I'm deeply obliged. ma'am. Deeply
Obliged.
Item 54.
Yes. No, this is the same thing.
No, my lords, there was the direction from the Honorable Division Bench, my lords, to carry out a verification exercise, my lords. In pursuant to those direction, a committee was constituted by the order of 16/2/2023. The verification, the final report, my lords will find, starts from page 3. That is the report, my lord. As far as the petitioner before my lords is concerned, the relevant.
You bring it on record. You bring this on record. Bring it on record. Third council for parties, the standing council APDCL submits that the verification process has been concluded and the petitioner certificate has been found to be invalid as he is found to be working on this in July 2012. Let this documents be brought on record by way of an affidavit by the APDCL authorities within 2 weeks.
No.
2 weeks.
In fact, my lords, on the last writ petition, my lords, the petitioner had filed, pursuant to this inquiry report, show cause notices were issued, my lord. Apprehending termination, my lords, they had approached this honorable court. A direction was issued to the APDCL, my lords, to give them a personal hearing and also provide them an opportunity of producing those documents. And that was done. Thereafter, my lords, he submitted a representation saying that he has additional document. We gave him a personal hearing again.
You bring everything
My
on
lords,
record?
it's part of the record.
Yes.
There is an interim protection, your lordship, may kindly extend it.
This again on.
But the date may be fixed.
3rd of September.
My lords.
The interim order will continue till the next day.
I'm very grateful, your lordship.
55.
Lordship, sorry for not being here on the first call, man. I was in another call.
But the main petition has become infructuous, my lord. That attachment order, my lord, now my lord has been withdrawn. And my lord, transfer order has been issued. And the same has been communicated to the petitioner in his personal email, official email, as well as the WhatsApp. This is the order, my lord. They have brought up a new cause of action in the IA. Probably, my lord, that will not cover.
What is the IA for?
I tell you, my lord, what happened. Lordship, so remember that the attachment order was passed on 16th of July, my lord. Subsequently, because of my ill health, I had taken leave, my lord. So on 2 occasions, my lord, when the leaves was sought before this entire incident happened, my lord, I just tell you the dates, my lord. I applied for the leave on 18th of July, my lord, and the leave was continuing till 31st of July. At that part, my lord, because I was not well, the leave was granted. Subsequently, my lord, after coming to the court and being disconduct, my lord, I had, because my back pain issue is existing and the doctors have given me 1 month rest, I had asked for another 1 month bed rest. That application now stands cancelled in terms of this. I mean, my lord, this is not I mean, I could have understood. My position remains the same. The medical record specifically say that I am not well. This is a persistent problem I'm facing. And now because of this, they cancel the problem will be if they do this,
But
my
then
lord.
you challenge this.
Yeah, it will have an impact on my service record because they will say that this period will not be counted.
You bring it on record properly, challenge it by way of a proper proceedings.
May I only request
Because
that some time should be
proceedings-
given to me because my lord, at least I
These
can ask.
proceedings are.
No, I agree,
How
my
much time do you require?
This is me a week's time, at least week, 10 days time, because my problem is
Week,
persistent.
10 days time to do what?
Because I'll have I need dress, my lord. This is what the application is all about.
You want your leave application to be allowed by the court.
My lord, I'm saying that at least 10 days time should be granted to me because this has now been rejected. I have no other option, my lord.
You have to challenge it.
This requested that could be
Yes, why
reconsidered, my
have
lord.
you rejected his medical application?
Medical.
Lordship will see, my lord, the ground has been given, my lord, page 23 of the I.
Page
will
23.
agree, you can always, my lord. Page 23. It is informed you that your application for so-and-so for 31 days, so-and-so has been approved by the Commissioner of Taxes, citing
not
reasons
been.
that, yes. Crucial juncture of revenue, my lord, augmentation, my lord. So we want, my lord, his service.
No, you want.
My lord, he can join there, he can take leave, that's a different issue. Lordship will see moment that prior to, my lord, he knows, my lord, that files have been moved. Immediately, my lord, before that, he suddenly becomes ill. He has got some back problem,
Right, heard.
and he's continuing.
My lord, my prescription is specific.
This cannot be granted, my lord. Main writ petition has become influential. How the IA can be considered? He can always challenge it, my lord. He has every right to challenge it. He can come up to tomorrow, my lord, with an unlisted motion.
We'll close your petitions.
Liberty
We'll
may be given
permit
to
you
him.
you are entitled to go and join in your new place of posting.
Yes, then
subject
apply,
to
ma'am.
Any such orders being passed.
Yes.
And you must be having some leave at your disposal.
Yes. You can always apply there.
That's an earned leaves. These are all earned leaves, my lord. I have said it in my application also.
Lordship will give that liberty to apply.
These are all earned leaves, my
In
lord.
his- Why are you rejecting this earned leave?
My lord?
If this is earned leave, then why are you rejecting it?
No, commuted leave, my lord.
Yes.
Commuted is a medical ground, my lord. He cannot say earned leave. His proper word is, my lord, commuted leave.
This is earned leave, my lord. I've said it in my application, para 4, my lord.
Oh, he will apply in another
No,
term.
where
my
is
lord.
your application?
Yes, my lord.
Commuted leave, page 21, my lord.
The commuted leave. Why are you saying earned leave?
Cannot be.
Heard. Mr. R.B. Fouquet, Direct Counsel to the Petitioner, Mr. B. Gugoi, Additional AG, for the state, respondent state. The present writ petition was filed by the Commissioner looking to challenge. Where is the impugned order in the writ petition?
Yes, my lord.
Page 46.
46, my lord. And except 10th.
The order dated 16 July 2025, whereby you are the first
Yes,
person.
he's the first to leave.
Whereby the petitioner was temporarily attached to the office of the Superintendent of Taxes, Naharkotia Unit, Naharkotia, the immediate effect. So, during the pendency of the writ petition, the transfer order was issued. During the pendency of the writ petition, the said attachment order, where is the attachment order is withdrawn?
My lord will find in the third page of my instruction that last night I placed on. Third page, serial number 5. He is directed to hand over his charge as so and the move parts. And last line is cancelled the so-and-so.
During the pendency of the writ petition, a transfer order dated 12/8/2025 was issued, whereby the petitioner was transferred and posted as Superintendent of Taxes, Office of the Superintendent of Taxes, Aflong Unit, with immediate effect. The said order also cancels, reflects that the earlier order, namely the order of attachment, stood cancelled. The learned additional AG submits that since the main challenge to the writ petition is no longer there, the writ petition has become infructuous and the same should be closed. Correct. The counsel for the petitioner on the other end has filed an IA, being IA number 2528. Sorry, 2662. Whereby he has prayed for granting him leave for some time as he suffers from chronic back pain, and for which necessary medical documents have been enclosed. It is the submission of the council that, as per medical advice, he is advised bed rest for
1 month. 1 month.
1 month.
Yes, ma'am. That's the one I've already filed in my IOs. That's it. Page 22 is the prescription.
Rest for 1 month. He can go and rest in his place of posting also.
Yes, my lord. My lordship will observe, then my lord, he will apply before his superior authority in the district, my lord. They will
And
continue.
my services are so much required, my lord, from Naharkotia. Now he's transferred me, attachment Naharkotia transferred me to Haflong.
You are entitled to put that to challenge, but it has to be by way of a proper procedure.
Yes, ma'am. I agree.
Advised bed rest for 1 month. He submits that he had applied for permitted leave for medical ground on by application dated 31/7/2025. And the same, however, stood rejected by order dated. Where is the order dated?
In the last page, my lord, it is.
That's not dated, my lord.
It's not even dated.
23. It's not
Was
dated.
subsequently rejected, being agreed, he has filed this IA. Since the writ petition had initially challenged the attachment order, and which stood cancelled by issuance of a transfer order, and the writ petition has become infructuous, it would not be proper to issue any orders in the IA which has been filed, which arises out of the same writ petition. Accordingly, the writ petition and the IA stands closed as the earlier order of attachment stood cancelled and the fresh order of transfer has been issued. However, this closure of the writ petition will not preempt, will not prevent the petitioner from making necessary application before the competent authority, seeking leave available to him in his account.
In the new
If
place of
such application is filed, the authorities will reconsider his prayer without being influenced by the rejection of his earlier application.
I'm extremely grateful.
It will, lordship will say, my lord, in his new place of posting, because here it has been rejected.
Wherever, what new place of posting, he will give wherever you, if the authority thinks he is not the competent authority, you refer it to the.
No, that one I'm not saying, my lord. He will have to apply there because now here it has been
He
rejected.
knows where to apply. He will apply wherever he wants to apply.
Extremely grateful. Extremely grateful.
Huh? There's another IA. There was another IA.
That was the amendment. That
All right.
become
In view of the order passed
yes,
today,
my lord, can be disposed.
IA number so and so is also dismissed.
Disposed. Extremely grateful.
I think 57.
Yes, any instructions?
Yes, Lordship. Lordship, here, as per instruction, the internal committee had concluded the report on 16/11/22
16/11
of 22.
22, my lord, the final report has been submitted by the internal committee, my lord.
To whom?
To the government. It has been concluded. It has been submitted to the principal, my lord. And subsequently, the final report has been submitted to the government, my lord. After that, my lord, the DP has started, my lord. Because the DP has commenced with effect from 2/5/2024, my lord. So both the proceedings were not running parallelly, my lord. After conclusion of the.
But he's entitled to know what the conclusions are.
Yes, my lord. He knows it, my lord. He knew it, my lord.
You serve copies.
My lord.
My instruction is that I have not been served copies.
And my lord, this is not about parallel proceeding. This is about whether procedure mandated by law has been followed or not. So they can start a DP and act upon that. They have to act upon
This is
this
an-
report. Disciplinary authority has to act upon this report, not any subsequent disciplinary proceeding conducted by him and act upon that.
This report also says he is guilty, my lord.
So you act upon that. You have there is a procedural lapse. It makes my case even more easier, my lord. They are admitting. Despite there being a report by.
My lord, when the notice was issued to him on 2/5/2024, my lord, that point of time he should have objected to it, my lord.
We will let the procedure and now we will find.
You file your pleadings, whatever is there, bring it on record.
Yes, my lord, I will file a detailed affidavit, but my lord, apparently prima facie, my lord, he is not entitled for any interim protection right now, my lord.
Interim protection, because these are not clear. You have not served him a copy. You have to serve him a copy.
Yes, my lord.
Of the findings of the committee. How else is he going to take recourse? There has to be a finding. And from a prima facie glance, without concluding, it appears to be a consensus act from whatever is recorded in the.
No, my lord, there some mention is there a call log or something like, because those were also.
No, there are certain findings that gifts have been given and this and that.
Yes, my lord. One gift mention is there, but otherwise some other allegations.
We are not making any observations at this moment. All we want is that you find out, you file a report, file an affidavit and
Yes,
tell
my
us
lord, I will
whether
file the affidavit.
proper procedure has been followed and whether he has been served with a copy. He has to be served with a copy.
Yes, my lord.
Only.
But my lord, interim protection may not be granted because apparently, my lord, it in both the
You
reports.
file the, why don't you file it and then we'll
I
hear
will
it?
file, my lord.
Yes.
But till then, my lord, because in both the reports he has been found
We
guilty,
had
my lord.
granted an interim protection after hearing both parties.
No, my lord, that time it was not before your lordship because.
So what have you brought?
Yes, my lord.
To compel the court to not extend the interim order? What materials have you brought?
The final report has been submitted by the inquiry
But
committee.
submitted to the authority.
Yes, my lord.
Have you served a copy on him? Have you indicated his appellate authorities? You have heard someone passed an order condemning him. The order is not served upon him. Then you start a proceeding and you complete the proceedings, transfer him. So we are examining the matter.
The transfer may be made, my lord, when the inquiry was going on, my
That is
lord.
what we are to examine,
Yes, my
Mr.
lord.
Bora. So please complete your pleading. We will continue with the hearing.
Yes, my lord.
Heard counsel for parties, Mr. D.P. Bora, learned standing counsel for the respondent on instructions have placed before the court a copy of the communication which encloses a report submitted by the Internal Complaints Committee to the competent authority. Mr. Bora submits that the copy of this order inquiry has also been served upon the petitioner, which statement Mr. Patwari, counsel for the petitioner, denies. You accept?
Yes, my lord, my instruction is that I have not been.
Denies on as per his instructions. Under such circumstances, his court considers it necessary that the respondents be permitted to respond to the contentions raised in the petition by filing affidavits if so advised. Let notice be issued, returnable 3 weeks. The respondents being represented by Mr. D.P. Bora. No further representing, you represent all.
Yes, my lord.
All the respondents, no further notice is required to be, notices are waived, however, extra copies be furnished, sufficient extra copies be furnished within 3 working days. The respondents may complete their pleadings and file necessary affidavit. Interim order passed earlier will continue till the next date fixed. Extension of the interim order will be reconsidered on the next date fixed. List on 15th.
Yes, ma'am.
15th September.
Interim to continue.
Yes. Till 15.
Yes.
Item 68.
Main please. Yes. Yes.
What I was pointing out to your lordship was that, my lord, for invocation of both the doctrines, namely promissory estoppel and legitimate expectation. Amongst other things, my lord, what is necessary is laying a foundation in pleadings. Those pleadings are in paragraph 2, 4, 6, 7. Most importantly, in 9, 10, 13, and 24. 2 sets out, my lord, averments to show when they were enrolled, when they completed. That is at page 96 to 99. And a detailed chart in support of those averments is at page 132. So, my lord, I just take your lordship to 2 or 3 parts of para 9. At page 107, about the 6th line from in that paragraph. On the other hand, those who had completed the said diploma and registered as rural health practitioners and accordingly employed under NRHM started agitation, submitted various representation to the respondent authorities regarding safety of their professional life with dignity. Then the respondent authorities on several occasions had given verbal assurance that shortly the government would pass a new act after observing all formalities, and by this new act, their rights, privileges, and identity would be protected. On the said assurance, they were continued in service as rural health practitioners as earlier appointed. Then, my lord, page number 111. Paragraph 13. The petitioners beg to submit that the action of the respondent state in enacting the Assam Act 2015 and issuing letters dated 6/11, 14/12, 10/3/2016 pursuant to the enactment was a legitimate expectation of the petitioner as well as manifested by provisions of the Act of 2015. The state is bound to carry out the mandate of the legislature, and the letters referred herein above are enforceable in law backed by legislative provisions. Then, my lord, I have already taken your lordships to the affidavit, which is narrated in paragraph 16. The 2 affidavits filed before the Honorable Supreme Court, my lord, I have taken your lordships in detail.
Right.
Now, my lord, on my lord, legitimate expectation, one more paragraph is paragraph 25, which your lordship will be pleased to find at page number 124. 123, I'm sorry. The relevant portion.
Yes.
Begins, my lord, at 123. About 6 lines. The petitioners humbly submit that their entire life and career are at stake for no fault of them, who, pursuant to a state act, had enrolled for education, acquired qualifications, ultimately secured appointment in the state services, and therefore the state respondents are stopped from defaulting from their promise of granting the petitioners the right to practice as allopathic practitioners in rural areas, Assam, and for providing employment opportunities thereto. It is therefore respectfully submitted that the effect and consequence of the statute cannot be wiped away by unconstitutionality of a statute, as it has caused to have irreversible consequences. So, my lord, whatever I have argued, I've laid the foundation in the pleadings. My lord, very surprisingly, there is no answer to any of these contentions in the report. I'm sure, my lord, he'll place it. Now, my lord, about the prospective overruling, paragraph 20, and I rely a decision of the Honorable Supreme Court, which is in that compilation. Paragraph 20 is at page 118. Petitioners,
Paragraph
paragraph 20 at 118.
20. Yes.
I had, my lord, placed that notifications where they constituted the committee to look into, my lord, the direction issued by the Honorable Supreme Court. Your lordship will kindly report. Then para 20, after having narrated that, the petitioners beg to submit that from the above quoted paragraph of the said judgment, it is apparent that the Honorable Apex Court, while upholding the judgment dated 30/10/2014, passed in WPC 5789 of 2015, declared the Assam Community Professionals Registration and Competency Act 2015 as valid law, as the Act of 2015 is not in conflict with IMC because Central Act does not deal with community health professionals who practice as allopathic practitioners in the manner as they were permitted to practice under the Act of 2004, meaning thereby diploma holders who have acquired diploma under the Act of 2004 can practice as allopathic practitioners as such professional in the manner as they were allowed to practice under the Assam Act, that is the ARA Act 2004, through the Act of 2015, which is a valid piece of legislation. It is respectfully submitted that the clarification given by the Supreme Court, it should have said Honorable Supreme Court, in para 25(4), essentially a prospective overruling. The doctrine of prospective overruling was observed by this court as a rule of judicial craftsmanship laced with pragmatism and judicial statesmanship as useful tool to bring about smooth transition of the operation of law without unduly affecting rights of people who acted upon the law that operated prior to the date of the judgment. So, my lord, all that I've placed, my lord, my submissions is all part of the pleadings. None of this has been dealt with by the state in the affidavit. Now, my lord, if your lordship please has the second compilation. Which is
No, you mean to say that these are not dealt with by the affidavit means
not denied. On the contrary, my lord, I don't want to embarrass my learned friend. Their affidavit starts by saying that we admit the contents of para 2, 3, 4, 5, 6, 7.
All right. Good for you.
Yes. That is, my lord. The affidavit, I'll just indicate. Affidavit, that paragraph is paragraph number 5. The statements made in paragraph 2, 3.
Page number?
For running page 5, their affidavit starts at 522, at 523, para 5 of their affidavit. The statements made in para 2, 3, 4, 5, 7, and 8 are admitted by your department only to the extent those are based on records. Now, my lord, all that I have submitted is on based on records, either the Honorable Supreme Court or their records, my lord, constituting committee, my lord, issuing orders.
You are referring, sorry, I am unable to get the affidavits.
I'm so sorry. My lord, if your lordship please has running page 522.
522 in this paper book.
In the paper book of the writ petition. That's the affidavit. Affidavit filed by the respondent. Affidavit in opposition on behalf of respondent number 1, Under Secretary Government of Assam, Srimati Pathak. Well, what my learned friend instructs me to state is it's separately there. It is separately
It's
there.
not here, it's not here.
No, because my rejoinder is also there. But that perhaps your lordships have is the judgment compilation. That is one. I'm so sorry. Well, I'm so sorry.
No,
When
this
your
is-
lordships overturned it, well, I just realized.
I have it. This is by the respondent 1.
Yes, Under Secretary Government of Assam. Please oblige me and have para 5 at 523. That statements made in para 2, 3, 4, 5, 7, and 8 are admitted by a deponent only to the extent those are based on records. Now I have annexed each of their documents to show. Then please see. Next paragraph. As regards statements made in para 9, 10, and 11 of the petition, your deponent states regarding various representations submitted by the rural health petitioner, it may be stated that all that they say is that this was struck down by the Honorable Guwahati High Court. Apparently, Gazette notification dated 29/5, the Assam Act of 2015 was notified to provide for registration norms and competency for community health professionals after passing BSc community health course, and to give them same status to the students who have or had been undergoing diploma in medicine and rural healthcare course in the Medical Institute, Jorat, with that of BSc, to enable them to serve as. Now, till here, my lord, they are ad item, but they put these two words as paramedical personnel in the state. That's all the stand is, my lord, that I could discern from this affidavit. Then, my lord, if your lordship now has the compilation, the judgment compilation.
Yes.
If your lordship, my lord, and there are certain principles of law, my lord, settled law, I'll not, my lord, request your lordships except to note down the paragraph numbers. I'll not like to eat up on my time. My lord, what I've done is I put it subject wise. Promissory estoppel, my lord. Motilal Padampat, paragraphs 8 and 4. Your lordship recall what I had, my lord, yesterday, but that continues to be the law. Because Godfrey Philip, I have therefore put, my lord, to prevent an argument which I had made, my lord, preparing for the union government, my lord. So Godfrey Philip, and I have also put in 2014 4 SCC 196. Well, if your lordship just sees running page 73. Of this compilation, the judgment starts. And in that, your lordship will be pleased to find the relevant portion at page 105, running page 105, para 35 of the 2014 judgment. Well, they have quoted estoppel as defined under section 115 of the Evidence Act. And after, fourthly, therefore, the doctrine of promissory, just above para 36, 3 lines, would apply only when based on a representation by the first party, second party alters his position in such a manner that it would be unfair to restore the initial position. My lord, here, my lord, therefore, my lord, I ask myself a question that A, was there a representation? Well, there could not have been a stronger representation than an act of legislature, followed by invitation of application, which, having knowledge of pendency of the petition, continued. 2, the second question that, my lord, would arise is that did I act on that representation? The answer in my humble and respectful submission would be yes, because I underwent the full course, my lord, succeeded, cleared that course. 3, they also acted on it by giving me appointments. And third, my lord, that have I altered my position to the detriment? I have, my lord. I have spent, my lord, valuable years of my life, my lord, in undertaking the course, and, my lord, at least 10 years of service. And if, my lord, it is calculated from 2008, we are in 2025, 17 years of service for the first batch. So there is no way. My lord, I must tell your lordship that, my lord, in the Honorable Supreme Court, the students went. The first name was, my lord, Baharul Islam. He underwent the full course, but he still was at that age. My lord, he completed around 18 or something. He had one last chance. So he, my lord, went into MBBS, completed full course. But others had no chance because by the time the age bar had come, we couldn't have taken, my lord, even if we were wanting to, we couldn't have taken any examination under the IMC Act. My lord, this is on accepting, or, my lord, on a demurrer that, my lord, our rights were not crystallized. On a hypothesis, my lord, even that, therefore, my lord, we acted completely to our prejudice, my lord. Therefore, the state, in my humble submission, is bound by this doctrine. Those are the everments. My lord, Motilal Padampat case, my lord, Chief Justice puts it beautifully at page 27, paragraph 16.
Yes.
The 5th line, the second edition of American jurisprudence brought out in 1966 in para 123 points out that equitable estoppel will be invoked against the state when justified by facts And though it does not want that this doctrine should be lightly invoked against the state, later in the same paragraph it is stated that as a general rule, the doctrine of estoppel will not be applied against the state in its government, public or sovereign capacity, but a qualification is introduced that promissory estoppel may be applied against the state even in its governmental, public or sovereign capacity if its application is necessary to prevent fraud or manifest injustice. What I fall under the later category of manifest injustice. And then their lordships, my lord, conclude at page 33 in paragraph 23.
Yes.
The contention, it was also contended on behalf of the government that if the government were held bound by every representation made by its intention when the exporters have acted in the manner they were invited to act, the result would be that the government would be bound by contractual obligations even though no formal contract in the manner required by Article 299 was executed. But this contention was negative and it was pointed out by this court that respondents are not seeking to enforce any contractual rights. They are seeking to enforce compliance with the obligation which is laid upon the Textile Commissioner by terms of the scheme. We are of the view that even if the scheme is executive in character, the respondents who were aggrieved because of failure to carry out the terms of the scheme are entitled to seek resort to the court and claim that the obligation imposed upon the Textile Commissioner by the scheme be ordered to be carried out. It was thus laid down that the party who has, acting in reliance on a promise made by the government, altered his position is entitled to enforce the promise against the government, even though promise is not in the form of a formal contract as required by Article 299, and that article does not militate against applicability of the doctrine of promissory estoppel against the government. In the law at page 41, paragraph 29, somewhere in the middle,
yes,
they refer to Indo-Afghan, and they say, well, I thought I must place this also in all fairness. It will thus be seen from the decisions relied upon in the judgment that the court could not possibly have intended to lay down an absolute proposition that there can be no promissory estoppel against the government in the exercise of its governmental or public or executive powers. This would have been in complete contradiction of the decision of this court in Indo-Afghan agencies case, Century Spinning and Manufacturing case, and Turner Morrison's case. And we find it difficult to believe that the court have ever intended to lay down any such proposition without expressly referring to these earlier decisions and overruling them. So, this was when the lordships held that it applies. I need not detain your lordships, Now, on the aspect of legitimate expectation, which goes hand in hand, your lordship may please go with me to page 697. 2 paragraphs. But in the index, your lordship would have noticed, my lord, kindly, that I have given running page numbers and the paras on which, my lord, I place reliance.
Yes, yes.
So that, my lord,
very grateful for that.
No, my lord. My lord is often said, my lord, our task ends when we conclude our argument. But then, my lord, the more difficult task begins. And one of them, my lord, in bulky record is to locate what the parties, my lord, place their submissions, my lord. This is only for the sake of your lordship's convenience. My lord, at page 697.
Yes.
The relevant paragraph is paragraph 15 and 16. That your lordship will be pleased to find. This is part of 1992 4 SCC, begins at 697. It appears at 714.
Yes.
That in any event, the new policy decision as contained in the impugned memorandum of January 20, 1990 should not have been implemented without making such change in the existing criteria for allotment known to group housing societies if necessary by way of public notice so that they might make proper representation to the concerned authorities for consideration of their viewpoints. Even assuming that in absence of any explanation of the expression first come first serve in Rule 6.6 of Nazul rule, there was no statutory requirement to make allotment with reference to the date of registration. It has been rightly held as a matter of fact by the High Court that prior to the new guidelines contained in the memo dated January 20, 1990, the principle of allotment had always been on basis of date of registration and not date of approval of the list of members. In the brochure issued in 1982 by the DTA, even after Gazette notification of Nazul rules on 26 September 1981, the policy of allotment on basis of seniority in registration was clearly indicated. In the aforesaid facts, the group housing societies were entitled to legitimate expectation of following consistent past practice in the matter of allotment, even though they may not have any legal right in private law to receive such statement. The existence of legitimate expectation may have a number of different consequences, and one of such consequences is that the authority ought not to act to defeat legitimate expectation without some overriding reason of public policy to justify its doing so. In case of legitimate expectation, if the authority proposes to defeat a person's legitimate expectation, it should afford him an opportunity to make representation in the matter. In this connection, reference may be made to the discussions on legitimate expectation at page 151 of volume 1 of Halsbury's Laws of England, 4th edition reissue. We may also refer to decision of the House of Lords in Council of Civil Service Unions versus Minister for Civil Services. It has been held in the said decision that an aggrieved person was entitled to judicial review if he could show that a decision of the public authority affected him of some benefit or advantage which in the past he had been permitted to enjoy and which he legitimately expected to be permitted to continue to enjoy, either until he was given reasons for withdrawal and opportunity to comment on such reasons. It may be indicated here that the doctrine of legitimate expectation imposes in a sense a duty on public authority to act fairly by taking into consideration all relevant factors relating to such legitimate expectation within the conception of fair dealing. In the case of legitimate expectation, the reasonable opportunity to make representation by the parties likely to be affected by any change of consistent past policy come in. We have not been shown any compelling reason taken into consideration by the central government to make a departure from the existing policy of allotment with reference to seniority in registration by introduction of a new guideline. I pause here with your lordship's permission. For the affidavit justifies nothing, my lord, to say, my lord, the least. That why did they not act? They formed a committee. The directions are clear. My lord, then on, my lord, your lordship's power to issue a writ of mandamus, my lord, I am relying upon a quite recent decision, but not in immediate past, 2022 SCC online SC 1018 at page 716. The two relevant paragraphs are paragraphs 18 and 19. The lordship will kindly oblige me. Yes. The judgment starts, my lord, at 716. Yes. And please see the relevant paragraphs at page number 18. Running page number 726. Yes. Therefore, it is clear, my lord, the lordships have discussed the entire law of, my lord, mandamus. That A, there has to be, my lord, a legal right, my lord, which in my humble submission I have. I must have made a demand, which I did, my lord, and met by refusal here is met by inaction, my lord. Therefore, it is clear that a writ of mandamus or direction in nature of a writ of mandamus is not to be withheld in the exercise of powers of Article 226 on any technicalities. This is subject only to the indispensable requirements being fulfilled. There must be a public duty. While the duty may indeed arise from a statute ordinarily, the duty can be imposed by common charter, common law, custom, or even contract. The fact that a duty may have to be unraveled and the mist around it cleared before its shape is unfolded may not relieve the court of its duty to call out a public duty in a statute or otherwise, if in substance it exists. Equally, mandamus would lie if the authority which had a discretion fails to exercise it and prefers to act under dictation of another authority. A writ of mandamus or a direction in the nature thereof had been given a wide scope in the conditions prevailing in this country, and it is to be issued whenever there is public duty and there is failure to perform, and the courts will not be bound by technicalities, and its chief concern should be to reach justice to the wronged. We are not dilating on or diluting other requirements which would ordinarily include the need for making a demand unless a demand is found to be futile in the circumstances which have already been catalogued in the earlier decisions of this court. Having cleared the air with regard to jurisdiction of the High Court in the matter of writ of mandamus or direction in the nature thereof, we proceed to next to the law relating the ambit of the court's jurisdiction in judicial review in contractual matters. Then, my lord, they see, and they say that even there, Lord, we had the famous case, my lord, of Dwarkadas Marfatia, my lord, where I want to place one paragraph that is given, my lord, separately. I somehow missed out in this bunch, my lord. There's a separate judgment, 1989, 3 SCC 293.
Wherever there is arbitrariness.
Your lordship's power under 226, my lord, would reach. It immediately springs into action, my lord.
Yes.
And that your lordship will recall was a contractual matter, my lord. At internal page 305, para 25. Therefore, Mr. Chinai, that's how the paragraph begins.
Para 20.
25, my lords.
25.
Therefore, Mr. Chinai was right in contending that every action activity of the Bombay Port Trust, which constituted state within Article 12 of the Constitution in respect of any right conferred or privilege granted by a statute is subject to Article 14 and must be reasonable and taken only upon lawful and relevant grounds of public interest. Reliance may be placed on observations of this court in E.P. Royappa versus State of Tamil Nadu, Maneka Gandhi versus Union of India, R.D. Shetty versus International Airport Authority of India, Kasturi Lal Lakshmi Reddy versus State of J&K, and Ajay Hasia versus Khalid Mujib Sherwarti. Where there is arbitrariness in state action, Article 14 springs in and judicial review strikes such an action down. Every action of the executive authority must be subject to rule of law and must be informed by reason. So whatever be the activity of the public authority, it should meet the test of Article 14. Sorry. So sorry. Mulot, then, Mulot, please see, Mulot, a recent Constitution Bench judgment. Now, Mulot, this was a unique case where the Kerala High Court, Mulot, had made appointments to the judicial service. That is, Mulot, under, it is under, Mulot, 5, Roman 5, P. Shivnandan, that is 2024 3 SCC 799. It's a Constitution Bench decision, page 542. They held, my lord, that the Honorable High Court in the matter of recruitment, there was violation starts at 542 of the compilation, my lords.
Yes.
It also, my lord, deals with the aspect of legitimate expectation at page 557, para 24.
Yes.
By the 90s, that's how it starts. The Indian courts incorporated the doctrine of legitimate expectation in the context of procedural fairness and non-arbitrariness under Article 14 of the Constitution. In Food Corporation of India versus Kamdhenu Cattle Feed Industries, this court held that public authorities have a duty to use their powers for the purpose of public good. This duty raises a legitimate expectation on part of the citizens to be treated in a fair and non-arbitrary manner in their interactions with the state and its instrumentalities. This court held that a decision taken by an executive authority without considering the legitimate expectation of an affected person may amount to an abuse of power. Para 7 of that quoted decision. To satisfy this requirement of non-arbitrariness in state action, it is therefore necessary to consider and give due weight to the reasonable or legitimate expectation of persons likely to be affected by decision, or else that unfairness in the exercise of power may amount to an abuse or excess of power, apart from affecting the bona fides of the decision in a given case. The decision so made would be exposed to challenge on the ground of arbitrariness. Rule of law does not completely eliminate discretion in the exercise of power, as it is unrealistic, but provides for control of its exercise by judicial review. The court held that whether the expectation of a claimant is legitimate or not is a question of fact which has to be decided after weighing the claimant's expectation against the larger public interest. Thus, while dealing with the claims of legitimate expectation, the court has to necessarily balance the legitimate expectation of a claimant against the larger public interest. Then, my lord, after having said that, please go with me to page number 563, para 40. Your lordship may only just mark 38 and 39 are other discussions on the doctrine of legitimate expectation. The principle, ultimately they say in para 40, of fairness in action requires that public authorities be held accountable for their representation. Since the state has a profound impact on lives of citizens, good administration requires public authorities to act in a predictable manner and honor the promise made or practices established unless there is a good reason not to do so. In Nanda Raja laws, justice laws held that public authority should objectively justify that there is an overriding public interest in denying a legitimate expectation. We are of the opinion that for public authority to frustrate a claim of legitimate expectation, it must objectively demonstrate by placing relevant material before the court. I wanted to lay emphasis, their counter, my lord, says nothing. That its decision was in public interest. This standard is consistent with the principles of good administration, which require the state action must be held to scrupulous standards to prevent misuse of public power and ensure fairness. Then, my lord, please see page 567. What the High Court had done was, my lord, the High Court's decision also fails to satisfy the test of consistency and predictability, as it contravenes the established practice. The High Court did not impose the requirement of a minimum cutoff for the viva voce for selection to the post of district and session judges for 2013 and 2014. Although the High Court's justification when analyzed on its own terms is compelling, it is not grounded in legality. The High Court's decision to apply a minimum cutoff for viva voce frustrated the substantive legitimate expectation of the petitioner. Since the decision of the High Court is legally untenable and fails on the touchstone of fairness, consistency, and predictability, we hold that such a course of action is arbitrary and violative of Article 14. So, Malod, there the selection was by the High Court. Then, Malod, they say, what should this court do? There was a pick-on situation. Those people were appointed, they continued, they acquired, Malod, relevant experience as, Malod, judges in the, Malod, district and other judiciary. Therefore, Malod, the question, paragraph 55, which now arises before this court in this regard to the relief which can be granted to the petition. The final list of successful candidates was issued on 6/3/17. Candidates who have been selected have been working as district and session judges for 6 years. In the meantime, all petitioners who are before the court have not functioned in judicial office. At this lapse of time, it may be difficult to direct either unseating of the candidates who have performed their duties. Unseating them at this stage would be contrary to public interest since they have gained experience as judicial officers in the state, in the service of the state of Kerala. While the grievance of the petitioner is that if aggregate of marks in the written examination and viva voce were taken into account, they would rank higher than the 3 candidates who are respondents to these proceedings. Equally, we cannot lose sight of the fact that all selected candidates are otherwise qualified for judicial office and have been working over a length of time. Unseating them would, besides being harsh, result in a situation where higher judiciary would lose the services of duly qualified candidates and who have gained experience over the last 6 years in the post of the district judge. So, Malad, there it was a reverse case. Malad, we have been in the service of the state, but the state's legislation continued for 10 years. Our services continued from 2008-9 onwards. Still, Malad, the decision was rendered, Malad, by this honorable court. Thereafter, I placed, Malad, contracts to show that it continued. Malad, suddenly, Malad, they want to downgrade us to the, Malad, level of, Malad, nurse on basis of an act after the decision of the Honorable Supreme Court, and that's why, Malot, I'm before your lordships. Malot, having placed this judgment, Malot, on Malot, I have prospective overruling, Malot, to prevent miscarriage of justice, Malot, is one judgment which I'd like to place, which is item number, Malot, L at page 278. Saving of vested rights, Malad. 2021, 6 SCC 568. Your Lordship may only note that this is also a constitution bench decision, my lord. The point of reference is at para 2.2, which your Lordship will be pleased to find at page number 301. My lord, again a case of doctors. At 301, the present bench of cases came up for hearing before another bench of 3 judges. The bench was of the opinion that the present batch of cases require consideration by a larger bench, and that is how the present batch of cases are referred to a larger bench. On the basis of submissions made, the following reasons were mentioned. The decision in Dinesh Singh Chauhan had not considered the entries in the legislative list of the 7th schedule, more particularly entry 66 of the union list and entry 25 of the concurrent list. The main contention of the petitioner is that while coordination and determination of standards in institutions for higher education falls within the exclusive domain of the union, list 1 entry 66, medical education is a subject in the concurrent list, list 3 entry 25. Though list 3 entry 25 is subject to list 1 entry 66, the state is not denuded of the power to legislate on the manner and method of making admissions to postgraduate medical courses. An akin, my lord, situation arising here. The entries are saying the question what was in issue was the power of the state legislature. Not having considered that, please go with me to para 9.2 at page number. This is the case which comes in my humble and respectful submission closest to, my lord, the facts of the present case. 9.2, they again record what I will not place before lordships in para 2.2. Now please see para 9.3. 9.3 sub para 3. Whether in view of list 1 entry 66, the state is denuded of its power to legislate on the manner and method of postgraduate medical courses, more particularly making special provision for in-service candidates in the post of postgraduate degree diploma courses. They held this issue, my lord, saying that the student is denuded of the power. But they say, what about, my lord, all those people who have, my lord, since been conferred? The benefits under that statute. Please come to, my lord, paragraph 17.2 at running page 361. Just, my lord, 4 lines here. It is settled that Article 21 of the Constitution of India confers on the citizens of India a fundamental right to life and personal liberty. Right to health is an integral part of right to life and is a facet of Article 21. In Devika Bishwas versus Union of India, after considering its earlier decision in so-and-so versus so-and-so and so-and-so and so-and-so, it was observed as under well established that the right to life under Article 21 of the Constitution includes the right to lead a dignified and meaningful life, and the right to health is an integral facet of this right. Well, having said that, my lord, please go with me to, my lord, page straightway, 366. My lord, by no means, my lord, I want to skip anything which is not, my lord, palatable to me. It's only because of constraint of time. But I've seen the judgments and marked out the relevant code. If there is something, my lord, lordship be rest assured, on the other side, I'll point it out. Page 366. Entry 1, I'm sorry, the list 1 entry 66 is a specific entry having a very limited scope. It deals with coordination and determination of standards in higher education. The words coordination and determination of standards would mean laying down the said standards. Then, my lord, skip all of that. Paragraph 23.8. The state has legislative competence and or authority to provide for a separate source of entry for in-service candidates seeking admission to postgraduate degree diploma courses in exercise of power under list 3 entry 25. However, it is observed that the policy must provide that subsequent to obtaining postgraduate degree by the in-service doctors concerned obtaining entry in degree courses through special separate channel serve the state in rural, tribal and hilly areas at least for 5 years after obtaining degrees diploma. For that they will execute bonds, and for such some the respective states may consider. It is specifically observed and clarified that present decision shall operate prospectively, and any admissions given earlier taking a contrary view shall not be affected by the judgment.
That is what is missing in the...
Correct. But, my lord, they have said it in a different way. Well, there are ways and ways of expressing. Well, that's why I wanted to point out, Malad. Lest it be said, that's why, Malad, this was the closest to.
So therefore, Apex Court, while upholding the setting aside by the Guwahati High Court of 2004,
And
has upheld the
2015 Act, which the entire exercise was done to protect those people. And this is, Malad, today we are in 2025. Not a single Malad advertisement, not a single Malad course under that ever started by the government acting on 2015 Act. And Malad, that's why I read, Malad, your Lordship will recall the statement of reasons and object and preamble of that Act, Malad, to give continuity of service and all the other benefits, Malad. Okay. Well, having said that, Malad, Malad, please also see 2021-11 SCC 401 at page 409. That is on saving of appointments. One paragraph, Malad, paragraph number 167. It's a very long judgment, Malad. 409. Again, Malad, a constitution bench, 5 honorable judges. Please go straightway to paragraph 167. Here the question was one of reservation. We cannot ignore a fact, paragraph 168, that a similar GO was issued by the erstwhile state of government of Andhra Pradesh in the year 1986, which was squashed by the State Administrative Tribunal at 533. Against which an appeal was preferred in this court, which was dismissed as withdrawn in the year 1998. After withdrawal of the appeal from this court, it was expected of erstwhile state of Andhra Pradesh not to resort to such illegality of providing 100% reservation once again, but instead it issued GOM number 3 of 2000, which was equally impermissible, even if the AP regulation of reservation and appointment to Public Service Act 1997 would have been amended. In that event, also providing reservation beyond 50% was not permissible. It is rightly apprehended by the appellant that the state may again, by way of misadventure, resort to similar illegal exercise as was done earlier. It was at least expected from functionary like government to act in the aforesaid manner, as they were bound by the dictum laid down by this court in Indira Sahani and other decisions holding that the limit of reservation not to exceed 50%. There was no rhyme or reason with the state to resort to 100% reservation. It is unfortunate that illegal exercise done in 1986 was sought to be protected by yet another unconstitutional attempt by issuing GOM number 3 of 2000 with retrospective effect of 1986, and now after that 20 years have passed. In peculiar circumstances, we save the appointments conditionally that reorganized state of Andhra Pradesh and Telangana not to attempt a similar exercise in future. If they do so and exceed the limit of reservation, they shall not be saving the appointments made with effect from 1986 till date. We direct the respondent not to exceed the limit in future accordingly. Order. So, Malad, what I'm trying to call out from this decision is, Malad, that wherever the court has found that, Malad, there has been substantive appointments, there have been, Malad, courses undertaken, persons have acted on the, Malad, actions of the state. Here, Malad, it is an act of legislature followed by the act of the state government. Then, Malad, those appointments, whatever be the illegality, Malad, is sustained by the court. And they are not, because, Malad, there is no way we can turn the clock back to that date in 2004. Malad, I'm done with this compilation. Malad, of course, Malad, it's like showing a, Malad, ray of light to the sun, Malad, prospective overruling or right to practice, Malad, I've already. So what I intended to do is, Malad, will hand over a note to your lordships, Malad, in case if it is not already handed over, but I have an extra copy. Please give one to the other side as well. Perhaps my memory was that when I gave the list of dates, I'm instructed to say that given that note, but this says, Malad, Malad, first, on a lighter way, there is contradiction in term. It says brief submissions, but it is at 8 pages. So it is, Malad,
Well, that is how a lawyer's brief is understood always.
My lord, what I've done is, my lord, I have set out, and I'm not, my lord, intend to read the entire portion, only some, my lord, I'll indicate if your lordships consider it appropriate to mark it, my lord. I've argued, my lord, the right to practice forming part of the fundamental right. That is in paragraph 2. Then, my lord, I've talked about the Assam Legislative Acts having been enacted by the state legislature prescribed qualifications for practicing allopathic medicine in rural areas subject to the restriction. So that is how I bring the case within, or attempt rather, my lord, I may say, within Article 19(1)G read with clause 6. It is essential to recognize that the petitioners had no role in enacting this legislation. They merely adhered to the legislative requirement of undergoing the course, acquiring prescribed qualification in an institution established by the state. I've argued all of that, my lord. Then, my lord, then please go to the next page. The repeal of a statute does not affect, this is my submission, my lord, for your lordship's kind consideration, affect anything previously done, liability incurred, or privileges derived. On the same analogy, the striking down of a statute will not affect anything previously done, liability incurred, or privileges derived during currency of the operation of the statute. The petitioners thus derived a vested right to practice, and this cannot be taken away merely on basis that the statute was declared invalid, more so in absence of any relief having been prayed for derecognition of the qualifications obtained by the petitioners during operation of the statute, and because no such relief is in fact granted in the writ petition that struck down the act filed with the Indian Medical Association, there being no declaration, such either sought or granted by the court, merely grant of relief declaring the state act to be unconstitutional by virtue of striking down the act, the qualifications so acquired under the statute during its operation, which now stands struck down, have neither become otious nor have got nullified, and hence the petitioner's right to practice cannot be affected. Then, my lord, I have tried in my own way, my lord, your lordship, I'm sure will reconsider and put it in the most appropriate manner. What are the issues which are present broadly? Whether there could be deprivation of the qualifications acquired with the petitioner during operation of the state on account of it being subsequently declared unconstitutional or ultra vires by a judgment of this honorable court dated 3010, as affirmed by the honorable Supreme Court with a judgment dated 24/1/23, and in other words, whether these judgments could operate retrospectively qua petitioners and their qualification. B, whether when the Honorable Court at the time of declaring ARA Act 2004 to be unconstitutional does not expressly incorporate the operation of the said judgment to have retrospective operation, is the said judgment deemed to be in operation prospectively. Whether the petitioners who were neither heard nor made parties to the litigation before the High Court can be deprived of their acquired qualification and livelihood. Then, my lord, the next page is on all the judgments that I have cited, my lord. This one paragraph, my lord, I wish to place, if your lordships permit me. Vested rights and prospective operation. The petitioners humbly submit that there could never have been any deprivation of the qualifications lawfully obtained by the petitioner during the operation of the ARA Act, since firstly, no such relief was either prayed for or granted. Secondly, the petitioners' rights could not have been deemed to have been affected as they were not parties. Thirdly, such declaration of the state to be state act to be unconstitutional in the facts and circumstances of the case can never be held to have any retrospective operation, and the judgment also does not provide for its retrospective operation. Fourthly, my lord, why did I put in this? There is a recent five honorable judges decision, my lord, in the CBI case. Your lordship will recall there was a single directive earlier, which said that if you want to investigate against, my lord, or start proceedings against an officer of the union government or who falls under the Delhi Special Police Establishment Act above the rank of Joint Secretary, you need clearance. That single directive was struck down, my lord. Your lordship recall in Vineet Narayan's case, my lord. Then the, my lord, Union Parliament reinstate that directive by virtue of section 6(8), which brought the same which was there in the office memorandum. Dr. Subramaniam Swamy challenged it and said, on that basis, what had happened was, my lord, there were prosecutions which were, my lord, either discharged or, my lord, quashing, etc. Both sides were, my lord, before the Honorable Supreme Court. In light of the fact that earlier it was, my lord, held to be invalid, they hold in that judgment, and I'll just place that judgment in the paragraph numbers, that, my lord, it has retrospective effect, specifically saying so. That, and yet they leave the question to be decided by the regular bench on the decision qua each of the matters which are travelled on facts. Now, that is why I put in this, my lord, third. Fourthly, there was no stay of operation of the Act while it remained in force for a period of 10 years, during which time petitioners either acquired qualifications entitled them to practice as RSP after their obtaining statutory diploma, their names having been registered in the state register, or in cases of batches 2012 onwards who were undergoing their education, which tenure was to end after striking down of the Act, on the ground that they stood admitted to the diploma course prior to striking down of the Act. Fifthly, in absence of any declaration by the court in the judgment, inter alia declaring the education qualifications acquired by the petitioners to be void ab initio nullity. Well, there's a typographical error, not nullified, nullity. The same cannot be either presumed or considered as necessary effect of the Act having been declared as unconstitutional. Lastly, in view of the specific direction of the Honorable Supreme Court contained in para 25(4). Then, my lord, all the judgments that I have cited, my lord, the relevant portions, my lord, I have put it here. Like, my lord, your lordship will recall, para 39.1 I cited, the statute which is made by competent legislature is valid till declared unconstitutional, my lord. So this is only, my lord, with a view to see that, my lord. Of course, your lordships have taken note, my lord. Then I put in at page number 3 or 4, Act of Legislature should prejudice no one. And my lord, there I have said, my lord, that it will cause, it has already caused, my lord, hardship. It will be iniquitous, my lord, and therefore, my lord, my prayer is to consider. I put in Article 21, Promissory estoppel, lordship need not. Now the last portion, my lord, as I'd indicated, my lord, objects of the NMC Act, your lordship will only permit me to read these 4 lines. One of the stated objects behind the enactment of the National Medical Commission Act is recognition of medical qualifications granted by newer medical institutions in India and outside India, see para of, and also for recognition of medical qualifications granted by statutory and other bodies in India as mentioned in the schedule. So, my lord, I have put in that, my lord, lordship recall Indoor Development Authority, where the word was or. My lord, taking a clue from there, I've said that N will have to be read disjunctively. Both objects are different in the, my lord, preamble of the Act. Then, my lord, this is the last alternative relief, my lord.
No, you are saying this N has to be read as or.
My lord, they have to be read disjunctively for the reason, my lord, your lordship will recall, my lord, the case of Sanjay Dutt, my lord, which had traveled to the court on the provision of Section 5 of my lord TADA. My lord, Section 5 said that a person in possession of a notified arm and ammunition will be charged with the offense. The argument was that please read the N disjunctively or as or, for the simple reason that if there are 2 persons, terrorists, my lord, one carrying arm and one carrying ammunition, neither of them can be, my lord, prosecuted. So there, my lord, it was held that in such circumstances, my lord, my lord, we did not have to travel that far. I've just put in here, my lord, while I was, my lord, drafting the note, my lord. My lord, the last portion was the need to avoid wastage of public resource. But the state has also had an institution. We have put in our, my lord.
What is the status of that institution? Is it still there or it's?
It is now converted, I'm instructed to straight into a full-fledged medical college.
Oh, okay. Jorat Medical College.
Yes. So, my lord, apart from the fact that I put in a separate subject that the professional reputation of the petitioners are at stake, my lord, recognition of qualification. My lord, I'd indicated yesterday that I want to place one particular section of the NMC Act. I know I've little overshot, just one, section 32, my lord. I'm sorry, section 35.
NMC Act. Yes.
But the first is akin to what you had, my lord, under 10A of the Indian Medical Council Act, 35(1). The medical qualification.
You're referring to which section?
Section 35, my lord.
35.
the medical qualification granted by any university or medical institution in India shall be listed and maintained by the Undergraduate Medical Education Board. Malad, in place of MCI, which was doing that work, Malad, you now have the Undergraduate Medical Education and the Postgraduate Medical Education Board, as the case may be, in such manner as may be specified by the regulations, and such medical qualification shall be recognized medical qualification for the purpose of this act. Malad, the spirit of section 10A is maintained, Malad, which said that all those qualifications which are required to be imparted by a recognized, Malad, medical college. Now, 2 is important. Any university or medical institution in India which grants an undergraduate or postgraduate or super specialty medical qualifications not included in the list maintained by the Undergraduate Medical Education Board or the Postgraduate Medical Education Board, as the case may be, may apply to that board for granting recognition to such qualification. Well, this is retroactive, meaning not which proposes to grant, it will, Malad, in my humble and respectful submission, apply to all situations, even where it is granted. Please see the words again. Any university or medical institution in which grants, it is, Malad, undoubted that Jorat is a medical institution, Malad, of the state. It granted a, Malad, undergraduate medical qualification, which was, Malad, for the time being, I'm assuming against myself, Malad, worst case scenario, which was never, and it's a fact that it was not included. Well, nothing stops from the state. Nothing stops the state from, Malad, saving the lives of these 609 people, Malad.
How is the medical qualification described here?
Yes, Malad. Your Lordship will also, Malad, see the words medical qualification not included in the list maintained. For that, Your Lordship may please go with me to, Malad, definition section. R. Recognized medical qualification means a medical qualification recognized under section 35 or 36 or 37 or 40 as the case may be. That's why, Malad, the legislature in 35 has used the word medical qualification not included, meaning, Malad, it need not be a recognized. But after it gets included, it becomes a recognized medical. So in that light, Malad, the last is what are the reliefs, Malad, that I have prayed for. The reliefs that Your Lordship will be pleased to consider, Malad, start at page 126, para 30. In Malad, they are in alternative to each other, Malad. At 127 of the writ petition. It is therefore most respectfully prayed. Am I with Your Lordships? That Your Lordships may graciously be pleased to admit this petition, call for the records, and issue rule calling upon respondents to show cause as to why. 1. A writ in the nature of mandamus shall not be issued directing respondents to notify the petitioners as allopathic practitioners in the manner as they were permitted under the Act of 2004 in the rural areas of the state of Assam in terms of para 25(4) of the judgment dated 24/1/2023 of the Honorable Apex Court passed in SLP Civil number 32592, 32593 of 2015, as well as transfer case civil number 24 and 25 of 2018. 2. A writ in the nature of declaration shall not be issued declaring present registration numbers of the petitioner as indicated under section 3 of the Assam Community Health Professionals Registration and Competency Act 1915 to mean to declare the petitioners as allopathic practitioners in terms of para 25(4) of the judgment dated so and so in the matter of so and so, wherein it was observed and recognized petitioners as allopathic practitioners and allowed to practice in the manner as they were permitted under the Act of 2004 through the Act of 2015. 3. A writ in the nature of mandamus shall not be issued directing respondents to frame rules and regulations and an appropriate scheme in respect of the petitioners as allopathic practitioners in terms of para 25(4) of the judgment dated 24/1 passed by the Honorable Supreme Court. 4. A writ in the nature of mandamus shall not be issued directing respondents to establish a regulatory authority to regulate and register the petitioners as allopathic practitioners in terms of so and so. Now, why this relief is paid is, that it can't be that if at all your lordships are so inclined and I'm able to persuade your lordships to grant me the relief, my lord, at whatever stage, or that their practice cannot be unregulated. Those restrictions will continue. And for that, authority is necessary. In the alternative as to why a writ in the nature of certiorari shall not be issued to quash the notice dated so-and-so, dated 6/8/2015, and a writ in the nature of mandamus shall not be issued directing respondents to provide the petitioners a unique identity as allopathic practitioners as have been recognized by the Apex Court, and accordingly redesignate their post and provide for a separate scheme of registration under the State Medical Register in terms of the Assam Medical Act 1999. A writ in the nature of mandamus shall not be issued directing state respondents to formulate the scheme like a condensed MBBS course. Well, this is the last. Well, at this stage of life, having spent so many years, my lord, we don't even mind, my lord, undertaking this or kind of a bridge course. My lord, it has happened so many times, my lord. There were, my lord, foreign educations, my lord, or degrees were not recognized. The ports have issued, my lord, directions for the bridge course. We don't mind, we'll undergo the rest of the, my lord. But, my lord, now if I'm told, my lord, I have become, my lord, I for giving an example, my lord, your lordship recall on the first day, wakils and pleaders all his life, my lord, he argued cases in court, and suddenly you're told that you are barred, my lord. It's too late in the day, my lord, to ask him to choose another profession. Then, my lord, as a one-time measure, so as to continue and complete studies to meet the standards of a recognized medical qualification as envisaged under the National Medical Commission Act, to bring on petitioners at bar with registered medical, writ in the nature of mandamus. My lord, short of this 6, my lord, I place section 35 to say that as one-time measure, my lord, your lordships can always mold the relief, my lord, though this is break law, that the state can be directed to apply, my lord, to the National Medical Commission, my lord, and include it under 35 too. Well, these are the reliefs, my lord. Well, I'm very grateful, my lord. I conclude with this. I rest my case, my lord, for a very patient hearing, my lord. And, my lord, I beg to apologize. I've overshot times on 2 occasions, my lord. But, my lord, I believe, my lord, the requirements of the case, my lord, required me to put these facts, the judgments, without repeating, my lord. I've tried to do my best. I'm very grateful to you, lordships.
May I plead the lordship? My lord, we have filed an affidavit, my lord, fraud affidavit, stating that what have been done, my lord, after enactment of the new act, my lord. So, my lord, the whatever direction or whatever observation is there in 25(4) at page 513, my lord. So, there is no any direction to the state, my lord. So it says certain observations are there. Now, my lord, the state government is doing whatever they are in the Act of 2015, my lord. After striking down of the Act of 2004 Act, my lord, 2015 Act has been enacted, my lord. And the state government has, my lord, done whatever they are to do in terms of that Act, my lord. The students who have already passed or who have undergone that course prior to 2015, my lord, so they have been registered as per that act, my lord. And my lord, they have been appointed as community health officer, my lord. And my lord, regarding the issue of allowing them to practice allopathy, my lord, it is not there in the Act of 2015, my lord. In 2015 Act, my lord, whatever is there, if your lordship peruse one again, my lord, 2015 Act, my lord, page 333. Registration is section 3, and then page 334, my lord, duties and functions of the community health professionals. Page 334, my lord. And then, my lord, the section 5 deals with the competencies of the community health professional. So, my lord, here in the Act itself, my lord, nowhere they have been authorized or allowed to practice allopathy, my lord.
What is the diploma that the petitioners underwent? Diploma in?
Diploma in rural medicine,
Rural-
rural health, in DMR.
DMR.
Diploma of Medicine in Rural Healthcare, DMRHC.
Now, my lord, if they are, because their main prayer in the writ petition is that, my lord, they should be allowed to practice allopathy, my lord. But in the act itself, my lord, it is not there. So how they can, we can allow them or we can grant them, my lord, if it is not in the act, my lord. Because section 4, my lord, specifically says for duties and functions, and section 5 deals with the competencies of the community health professionals.
Where is the definition of community health professionals?
That is, my lord,
Definition
page 332, my lord.
2C.
332, my lord. Yes, my lord. 2C, my lord. Community health profession means the persons who have been registered as such by the director and issued a certificate of registration in accordance with the provision of section 3 of this act. So section 3 deals with the registration, my lord. So it says, my lord, the student 3.2 says the students who have already completed or have been undergoing the Diploma in Medicine and Rural Healthcare course in the Medical Institute Jorhat on the date of commencement of this act shall be deemed to have completed or have been undergoing, as the case may be, the paramedical course of BSc for the purpose of this act, and shall acquire the same status to that of BSc graduate, and they shall also be registered by the director and issued with certificate of registration as community health professionals. So now petitioner, by virtue of this provision, my lord, now the petitioners are community health professionals, my lord. And they have been allowed to practice whatever they are in section 4 and 5.
Where do you find the term of allopathic medicine or allopathy defined?
That is in one of the judgment of one of the Honorable Supreme Court.
No, it must be there in some statute. Who is an allopathic practitioner? Or
Yes,
who-
that was there, my lord. If your lordship will go with me to the 2004 Act.
2004.
My learned friend relied upon 4.1. CHP may be designated as CHO, and the duties here in paragraph 30 are of CHO. They consciously don't talk about what CHP will do. My lord, please have the 2004 Act, which is at page number 159 definition. 2G, medicine means allopathic medicines but does not include veterinary medicines. Medical and rural healthcare means practice of allopathic medicine and healthcare system in rural areas in the state of Assam. That is why, my lord, 26(4) has that nomenclature.
No, but this allopathy medicine must be
Defined under some other act.
Some other act.
Yes.
That must be NMC Act or.
Well, under
Indian
the
Medical-
IMC Act, it was defined. IMC Act, my lord, if your lordship please has.
Indian Medical Council.
Yes. It defined, my lord, medicine means modern scientific medicine in all its branches. So allopathy is taken as a branch. That is 2 subsection F of the 1956 Act. Indian Medical Council Act 1956. You have one more act. Indian Medical Council Act.
We'll keep it for another day.
Very good. My lord,
Just
your
in case
lordships
we have
don't
some
mind,
queries.
there is some marking in my book, my
No
lord.
problem. Thank you.
Please keep my lord both side by side, page 159 and my lord 2.
This is reproduced in NMC.
Yes, as
I think G or something.
Or still
J. 2J.
Yes. What you may please have section 2. Medicine means modern scientific medicine in all its branches and includes surgery and obstetrics, but does not include veterinary medicine and surgery. Malad, verbatim the same, Malad. Now, just Malad for comparison, please see 159 and place Malad both 2J of NMC Act and 2G of that earlier act. Medicine means allopathic medicine but does not include veterinary medicines. And medicine and rural healthcare means practice of allopathic medicine and healthcare system in the rural areas in the state of Assam. And see the kindly see the definition E at page 150. Diploma in medicine and rural healthcare means diploma awarded by authority on successful completion of course of so and so under provisions of this act. Therefore, Malad, the first plank of my argument is completely even independent of 26.4 on the ground that it doesn't wipe away. 26.4 only, Malad, supports that. In the country, I'm sorry.
No. Okay.
Where is the 15 Act?
This is my lord, page 3.
Starts at 331.
Yes.
Whatever it is
Where
stipulated.
has this term allopathy been incorporated from? What does it mean?
Well,
in the context of
generic
practice of medicine?
Yes.
General understanding apart.
Yes.
Is it defined in any rules or regulations or modifications? Or say Unani or Ayurvedi or
Malad,
something is.
Malad, let me just check, Malad. I'm instructed to straight, but I'll just.
Just check.
From allopathy is not.
No, so they can go.
I'll have to check that. Often I don't want to, Malad. It will not be proper, in fact, Malad. In normal sense of the term, we always know as Malad, allopathy medicine is something which gets Malad available on a prescription by a registered medical practitioner. Malad, like for Ayurveda, of course, you have different shops. Unani medicine is different. I'll have to check up all the three acts, my lord. This, I would
There is this judgment where homeopathic doctors were also permitted to.
Yes, my lord, that is in the judgment, my lord.
Allopathic.
That is, my lord, if your lordship has the judgment of my lord D. Mukhtiar Singh, 1998, 7 SCC 579, 119 of that compilation.
Okay.
Your lordship, go with me. This uses the word allopathic drug at page 125. Fourth line, the controversy in these cases was triggered off by at page 125. Issuance of a declaration by the state government under clause 3 and rule 2 EE of the drugs. Just check this. Of the cosmetic rules for the drug which defines registered medical practitioner. Under such declarations, notified Wahid Hakims claim right to prescribe allopathic drugs covered by the Indian Drugs and Cosmetic Act, for short the drugs. Furthermore, Wahid Hakims who have obtained degrees in integrated courses claim right to practice allopathic system of medicine. In that, my lord, this judgment considers at page 126, para 7, 6th line, the rule in question submits the learned senior counsel was framed under the Drugs Act and having regard to the factual position that qualified allopathic doctors are not available in rural areas and that persons like appellant petitioners have been catering to the medical needs of residents of such areas. As such, the rule is in public interest. The rule, it is argued, cannot be said to be illegal for want of legislative competence, as Section 33 of the Drugs Act confers very wide power on the central government to frame rules. As class of medical practitioners postulated by clause 3 of the rule can properly be identified with the state government, they are empowered to declare by general or specific order. Such class and notification issued by various state governments are well within the right of the rule. And then, my lord, please see page 128, para 17, the subpara. The systems of medicines generally prevalent in India are Ayurveda, Siddha, Unani, allopathic, and homeopathic. In the Ayurveda, Siddha, and Unani system, the treatment is based on harmony of 4 humors, whereas in allopathic system of medicine, treatment of disease is given by use of a drug which produces a reaction that itself neutralizes the disease. In homeopathy, treatment is provided by the like. Then they trace the history, my lord, of medical system that are vogue in India. Ayurveda had its origin in 5000 BC, is being practiced throughout India, but Siddha is practiced in Tamil-speaking areas of South India. These systems differ very little from both in theory and practice. Unani system dates back to 460-370 before Christ, but that had come to be practiced in India in the 10th century AD. Park, Textbook of Preventive and Social Medicine, 15th edition, pages 1 and 2. Allopathic medicine is comparatively recent and it has its origin in 19th century. Noticing that for practicing allopathic system of medicine, degrees and diplomas were issued by private institutions to untrained or insufficiently trained persons, and some of them were colorable imitations of those issued by the recognized universities and corporations, which was resulting in unqualified persons posing to the public as possessing qualification in medicine and surgery, which they did not possess. The Indian Medical Degrees Act 1916 was enacted to ban conferring of degrees or issuing certificate license.
There are 24 and 25.
Yes, my lord. I have them marked, my lord. And also, my lord, if your lordship has, my lord, paragraph number paragraph number 38 at page 135. Well, about just 2 lines above placitum F, one line. It is thus possible that in any state, the law relating to registration of practitioners of modern scientific medicine may enable a person to be enrolled on basis of qualifications other than recognized medical qualifications, which is a prerequisite only for being enrolled in the Indian Medical Register, but not for registration in the state medical register. So, Malad, that term used.
Your primary grievance is that you are to be recognized as an allopathic practitioner, as was done in the 2000.
Under the Act. And Malad, that is why those words or those two lines in para 26(4), which is part of the conclusion or the direction, Malad, is very important. Now, may I just place that again at the cost of repetition? That comes at Malad page 513. I'm thankful. Consequently, the subsequent legislation, namely the Assam Act of 2015, the Assam Community Professionals Registration and Competency Act. Please see, Malad, it is a registration act. Enacted pursuant to judgment of the Guwahati High Court is a valid piece of legislation, as it has removed the basis of the impugned judgment passed by the Guwahati High Court. The 2015 Act is not in conflict with the IMC Act 1956. This is because the Central Act, namely IMC Act, does not deal with community health professionals who would practice as allopathic practitioners in the manner as they were permitted to practice under the Assam Act in the rural areas of the state of Assam. Hold on, I pause here. CHP does not say that CHPs will be permitted to practice allopathic practitioners. It does not say that they will they were permitted to practice under the Assam Act, nor does it say in the rural areas of the state of Assam. Hence, by a separate legislation, the community health professors have been permitted to practice as such professionals. It takes its color from the earlier law. Well, your lordships have this vast experience, my lord, of penning down judgments, my lord. Your lordships, or my lord, from a general perception, your lordships, my lord, if I may say so with respect and utmost humility, are right. That, my lord, they could have said it in different ways, but they have chosen to say it in this way.
All right.
Very grateful.
So we will have to continue.
Yes, ma'am.
On some other date. You have concluded the
I have concluded.
Primary arguments, Mr. K. N. Rawal.
No, my lord. He was, my lord, a colleague of mine from Gujarat.
I'm sorry.
Since deceased, my lord.
I'm so sorry. I'm sorry.
No, Harin Rao.
H.P. Rawal.
Lordship.
I'm so sorry.
No, not at all. My lord, a very distinguished colleague at the bar, my lord. I had
Yes.
an occasion to oppose him in large number of matters in the Gujarat.
Was he also an ASG?
He was also an ASC and also then, my lord, learned Solicitor General of India.
Okay.
Unfortunately, my lord, we lost him. But, my lord, one of the founder persons responsible for establishment of, my lord, national law universities. It was, my lord, he was one of the main, my lord, person who, my lord, projected that to have qualified professional lawyers in a, my lord, integrated course.
Mr. H.P. Rawal, counsel, senior counsel, assisted by Mr. Shakil and Mr. Mazumdar. Adili. And Mr. Mazumdar for the petitioners, and Mr. T.P. Bora, standing counsel for the health. The counsel for the petitioner has concluded his arguments. Matter be listed again on 21st, we'll keep it, but we don't know. Where it will be available, Mr. Bora,
Mr. Vora has to.
21st.
Can I be excused on 20?
Yes, yes.
In case of some more clarification or requirement, I'll come back, Malone, whenever your lordships so directs.
28th of August for the arguments of the state.
Very grateful.
Recording.
I once again, Malord, express my extreme gratitude, Malord, to your lordships, and it has been a real pleasure, Malord.
Thank you for all the compilation and the detailed submissions that you made. Rest, of course, depends on us, how we deal with.
Yes, Malord, of course. Malord.
All right.
Malord, I believe that parted will continue, so it finds it mentioned appropriately in your lordship's cause list.
Which one? This matter?
Yes, Malord.
Yes, yes, yes. Parted will be there.
Yes.
Reflected.
Otherwise, again, somewhere it will, Malord, go down, Malord.
It normally remains parted.
Lordship,
Yes.
much of that. Very
Yes.
good. I wish your lordships and all your lordships colleagues, Malord, a happy independence.
Thank you. Same to you. Thank you all members of the bar.